Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
They got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
As the agent for Peyton Ansley, John Milton, you are indicating to me that you're quite familiar with Peyton Ansley, John Milton, and that's basically you. Is that correct?
I am the agent authorized to represent Peyton Ansley, John Milton, as written in all capital letters.
All right, and you understand for my purposes, though that language doesn't make any sense. So
No, I do not.
I understand. Okay, well, I'm telling you that. And so I am, until you disabuse me of the motion, or the notion, I am inclined to believe that you are both the agent and the person. So. And it's
I'm not a person, I am one of the people, thank you.
Okay, thank you.
I'm not a person, I'm one of the people, and I am the Recovery Addict. Thank you for joining me here in the Court of Public Opinion this morning. I'm a little quiet this morning. Is that better? Good morning. Welcome to the Court of Public Opinion. I am the Recovery Addict. I'm not a person, I'm one of the people. One of the people here. We've got the matching lights, matching shirt. We got a little purple on the screen as well. I think we're feeling purple today. I don't know what color the Texas Rangers have as their color.
I'm not a cat.
I'm pretty sure it's not purple, but big congrats to the Texas Rangers. What is it, like 62 years or something, and they finally won. This is a huge win. But the biggest win, I know this is not a sports show. You guys did not come here for sports news. The biggest news, actually, is not that the Texas Rangers won.
Because he's the guy.
It's some guy named Will Smith. Will Smith has moved to 3 different teams in the last 3 years, and those 3 teams have won. We have a good luck charm. I don't know who wants to trade for this guy now. I don't know if he went up to bat or anything. I don't know anything about the game. Zero. But if I were a team looking to win the World Series next year, I would trade for Will Smith now. Anyway, I'm not even sure if he's available to trade. But anyway, that's the news from me as far as the sports world. Welcome. I'm a little bit...
It's
not relevant. I do apologize. First of all, we've got a couple things. First, Jan, before we appropriately welcome you, we have to say Inez. Is it Inez? Ines? I don't know who it is. We have your name spelling, and we're going to create a record for you, a rap sheet, if you will, because you have been first in chat today. And I'm not sure if you paid attention on previous days, but the first person in chat every day is punished for their sins. You typing first in chat, breaking the silence, the stillness of the air. It's also a reward, though, something you can claim on your resume. It's also on your rap sheet. But you are going to be rewarded everything IP-related worldwide, and you just have to maintain it. We'll forward all the calls to you. So just be prepared for the influx of calls that you are undoubtedly will receive. Congratulations. Thank you very much. Look, there I am. Hey, I'm here. It's early this morning. It's early. I'm not quite sure what I'm doing up this early, honestly. This is, it was rough. I barely got my Instagram picture posted of these 3 trees this morning. And now here we are in court. Or about to be in court. We are anticipating a feed from the courtroom as we have a couple things happening this morning. We need to probably talk about birthdays. I know we have one notable birthday. Whoever's here watching right now, you share your birthday with one very notable person. Court is streaming today. It's my understanding that we are streaming today. It's going to be a little bit technical. It's going to be in the weeds a little bit. No jury. Probably, I'm not even sure if we'll have Jack there. The Kowalskis will probably not be there at all. But this is going to be the rules. We're fighting over the rules that the jury's going to use to deliberate, and that will be very important. Might even go over the verdict to the jury verdict form. That'll be very insightful for many of us. The judge has some DV rulings that are coming in first thing. Anyway, we need to, but going back to birthdays before we go too far, let's see, Saren has a birthday. Saren shares a birthday with one notable person who we love on this channel, and that is Judge Stephanie Boyd. It is Judge Stephanie Boyd's birthday. So we're going to sing to her as well. Let's see, Judge Stephanie Boyd, Judge Boyd, I think, Saren. Let's see how I share a birthday with Mickey Mouse. I don't know. Is that today? Is that today? Well, we're doing that. Jan Gold, welcome to the gallery as a new member. Thank you very much. Also joining you this morning is Lisa Marie Pritchard. Welcome, Lisa Marie. Good to have you as well. Matt Bond, sup, Spiffy Lump. I swore I'd get this right the first time. Sup, Spiffy, legal mumbo jumbo talkie recovery dude. Welcome, Matt. Good to have you here. Good to see you also last night with Rob over on Lawn Lumber. Loved his breakdown yesterday. It was amazing. Courtney Meek. Go Rangers! Whoop whoop! All right, we got a fan in the house, so welcome, Courtney. I'm hopefully you're able to stay up and stay awake while we go over everything today. You didn't party too much with the win last night. All right, where are we at? Birthday. My birthday is today too. Michelle, we'll put you in here.
Is that correct?
Okay, so there was a buffer sound in there. We've got to sing quickly because court's going to begin. My birthday is Saturday. We're going to sing to you tomorrow then. You've got to be here tomorrow. Let's see. Marianne Ponte and Michelle. Okay, so Marianne. So here's what I have. Here's what I have on the birthday list. I have Judge Boyd, which for some reason says Stephanie Old because my keyboard doesn't work right and it's spell checked. Spell corrected Boyd to Old. I'm sorry, Judge. That was not intentional. Thank you, Meso's mom, for gifted a membership. I think we have. Here's what we have in birthdays: Stephanie Boyd, Judge Stephanie Boyd, Saren, Michelle, and Marianne. Does that work? It's my birthday too. Lexi as well. Lexi, we're gonna get a long list here. Okay. And while this is prepping, I need to get the video feed going, which would be sort of important to have a feed for today. Where are we at? There we go. Okay. So we have that going. And let's start singing before the judge shows up, because I'm not sure how he would accept this if he heard us singing in his court. Oh, no. Hold on. Okay, everyone sing with me, please. I've got a little bit of a sore throat thing. We'll try this. Here we go. Happy birthday to you. Happy birthday to you. 2 verses, I think. Happy birthday, Judge Boyd, Saren, and Michelle. Happy birthday to you. Okay, we have an interlude, and then we're going to go to verse 2. It's going to be Marianne and Lexi. Is there anyone else that needs to be with Lexi? Not sure. I think this is it. Okay, just Marianne and Lexi. Everybody this time. Loud in the back. I can't hear you. Ready? Happy birthday to you. Happy birthday to you. Happy birthday, Marianne and Lexi. Happy birthday to you. All right, happy birthday to all the people, says Michelle's Mixed Media Madness. Thank you very much. Happy birthday to everybody that has a birthday today. For those that are celebrating today, I know there are a million places it could be. Some of them will even give you free pancakes for showing up, like Denny's. I would encourage you to go there, but the fact that you're here with us this morning, celebrating your birthday, and allowing us to spend this special time with you is not lost on me. Thank you for the honor and privilege, and there was another pleasure. That was the word I was looking for. Hope you have a wonderful, wonderful birthday. Thank you so much. But now we have to stop celebrating your birthday because court is about to begin. And let's see, buffer. Etta, Reverend Beezy's daughter, Etta. I'm so sorry, Etta. Happy birthday, Etta. Reverend Beezy's daughter, Etta. I hope, Etta, you have your very own emotional support zebra. Reverend Beezy sent me this one, and I keep it attached to my microphone for some times when I just need to reach over and just have a little bit of stability in my life. Etta, hope you have a great birthday. Thank you very much. All right, there we go. Thank you. It's this cold and this sound machine. That's what I give the credit to on the voice. All right, we are getting ready to join court. Let's see what we have right here. We do have a feed. Well, let me see if we can get another one pulled up just for duplicity's sake. There's a word of the day, duplicity. Oh, didn't today just feel like a brand new day to everybody? Was it like, it was, there was a song, I'm going way back. My sister's boyfriend, when I was in high school, wrote a song. And it's something like, everything's brand new, everything's soft sunshine, the love that may be true is saying that she'll be mine, everything's brand new. That's how I'm feeling today. It's just like a brand new day. I'm just happy. And I know what it is. I did not worry about my cat last night. Yes, it's freezing outside, and it's an outdoor cat, and it's obviously its first winter because it's a young cat. But I didn't worry one bit about the cat, because I went out and I found in my recycling one of the boxes that I keep. And I got this box, and then I went through my closet and I found a hoodie that it was actually a hoodie that I used when I was filming college football games. It's like the staff, the video crew hoodie. Well, it's shrunk over the years, just around the middle section. The sleeves are about right, but it shrunk around the middle section. So I donated this hoodie, and I folded it around the box and everything. I made a little tunnel so it can like tunnel in. And I no sooner put the box down than the cat was like zoop in the box and like curled up, and he didn't want to come out. It's like all right. And he stayed there all night long, slept nice and warm, came out, was fat and happy in the morning and ready to eat. So I would worry if he was cold last night. Anyway, that's all. Is this the hoodie you're giving away? No, this is an old hoodie. The hoodie we're giving away, we need to get to that as well. Let's see. I need... The hoodie we're giving away is related to this contest right here. And let's see if we can get some information on just where we are on this contest. I need DSK2. There we go. Here we go. All right. We've got to jump far ahead. 1726 is where we're at right now. So let's see. We'll let that play for a little bit, just so the losers can see that they were actually on the list, and the winners who are coming up can see how close they are. They have heated kiddie beds. I realize I'm not sure if we're going to go that far. I don't know. Let's see. Oh my goodness, the IJ Commission report. Oh, we passed it. Let's pause for a second. Pause. Who is currently in the win? It's tie. It's a tie between Terry Caldwell and Amy Cornell. It's a tie right now. So, Amy, I think you're in better position of the two of you. But wonderful. We're super excited for this contest, and it's very soon. Monday, the contest will end, because that's when we have closing arguments according to schedule. For those that missed yesterday, and also missed Rob's wrap-up. I don't think there were many of you that missed. He had like 8,400 people in his live stream. It was crazy. But who missed Rob's wrap-up last night. This IG Commission report that we're talking about is a huge, huge issue. Rob went through and spelled and brought out all the breadcrumbs of the groundwork that the plaintiff laid to get to this point. That not just the groundwork, but the chess moves, as he uses, he says 4D chess, the chess moves that were played that made the judges here already, holy cow, that made the defense feel they needed to take the moves they did.
Thank you, Mr.
That
Reyes, for being
enabled
here.
this. Password.
This is
PASSW
case number 2018 CA 5321 NC. It is Jack Kowalski, etc. et al. Versus Johns Hopkins All Children's Hospital. Let's go ahead and take appearances, starting with the plaintiffs.
Greg Anderson, Nick Whitney, Tom Elliott on behalf of the plaintiffs, Your Honor.
Chris Altenburn and Patricia Crawls on behalf of Johns Hopkins All Children's Hospital.
Okay. My suggestion, unless there's a better way of doing this, is just start on page 1 and proceed.
So this is going to be a little heavy in the weeds.
Feed up, but I need to turn on his authority to do that. There you go. You should have the authority now.
And to confirm, we're working on what is called working copy of instructions, November 1st, 23 at 2:15 p.m. Is that the ones we're using?
Let's make sure.
Your Honor, do I need to hop into your Zoom and then throw that over? Is that what we're trying?
I need you to be able to put it up on the the monitors so that the TV folks can grab the feed. So I guess yes, the answer to your question.
Okay.
Chris, where's the timestamp on this set?
Okay, so it's going to be a little.
I don't think there's a timestamp. They were just emailed into.
Court's going to be bare in the court.
Record. In fact, at the end of the hearing, I was going to suggest that I don't know that there are any comments on the side that need to be redacted, but it might be simplest to just have my office create a PDF of this and do a notice of filing that this was what we discussed for the hearing for preservation purposes.
Greg, I'm going to forward it to you right now.
Okay.
I will say the following. On a going forward basis, my office is going to take control of making further changes to the document. So on a going forward basis, I will be the owner of both the jury instructions and the verdict form.
I'm confident that makes both parties happy.
That's work the judge just took on his shoulders. Actually, his clerks.
Reyes will get this up on the screen for the TV folks here momentarily.
Your Honor, while we're waiting, obviously the couple things you have under advisement will impact some of the instructions. I didn't know if you were.
I'm going to roll that in just a moment.
Okay.
You can take notes on rulings and things like that.
Okay.
Court is bare, but this is crucial. What happens here today? What happens here today is very, very important.
While Mr. Reyes is working on that, this is what we're going to do with the two directed verdict motions that are.
No, I know. I can do it from here. I don't want to go over there. Yeah.
What I'm going to do for the two directed verdict motions is I'm going to continue to maintain them under advisement, and I am going to allow them to go to the jury, but technically I will keep them under advisement. So we need to have the verdict form and the instructions with the instructions for those two counts and places on the verdict form for those two counts. So that's how I'm going to handle it.
He says they are going to the jury.
Thank you, Your Honor.
But I'm going to keep them under advisement.
There are drafts of those in there.
Unplug what, my cable?
Mr. Reyes. Yeah. At this point, I'm going to go ahead and. Oh, I think Mr. Reyes just had success. Okay, the first thing I guess is on page 4.
I believe that's correct, Your Honor.
It is entirely proper for a lawyer. We're going to put that where we normally would put it. It's not going to get top billing.
Well,
it will
the
just
only reason I asked for that was that, this case has been a little unusual that this issue has come up repeatedly as recently as yesterday afternoon. It's not normally in a spot that's highlighted, but I accept the ruling.
The instructions contain an instruction that says all the instructions are important and follow all of them. So I'm just going to put it where it normally goes. Page 5. Now.
Well, right after that, there's during the trial you've heard evidence about policies and whatnot. And I'm not 100% sure there's agreement on that, but I thought there was.
Oh. I assumed if it was not highlighted or in a different color that it was agreed to. Was that an incorrect assumption?
That should be a correct assumption, Your Honor. I think this is where we ended up on this one.
Yeah. So then on page 5 is during the trial you've heard testimony.
Okay. So my thoughts there, where it says the order ended the lawsuit in the dependency court at the end. Should I also not add the statement in all existing orders? That order ended the lawsuit in the dependency court in all existing orders, period.
I have no objection to that. I wasn't sure you wanted that, so I didn't put that there.
Orient me again, Chris.
On page 5, top, the first full paragraph at the very end, the sentence says the order ended the lawsuit in the dependency court. And Your Honor wishes to add what additional language? I'm sure you'll get it right. I'm trying to figure out.
They have not addressed the bombshell. I'm not sure how much they're going to go into today.
And is that
how much will be on
order
Monday.
by any chance going to be, is the court ever going to consider revising the original instruction on dependency court orders that was read halfway through?
Well,
we had a couple points if we ever get to that.
I mean, I think I told everybody when I came up with that if there was slight revisions we need to make before it gets into the final version, I would be willing to entertain them.
That was my understanding, Your Honor.
I'm not asking for anything. I would say the final order in that dependency court is one of those, it's a plain vanilla one-sentence order.
Well, in any event, what for this top paragraph, talking about the order to administer ketamine, I was going to leave that paragraph in and add the clause "and all existing orders" at the end of that the last sentence of that paragraph. And then I was going to leave in the next paragraph. During the trial, you have heard testimony about stress-related.
Allegedly.
I was going to leave that in.
Allegedly, Ella. Hunter had a bad day.
The following
yesterday.
paragraph, that yellow highlighted language, to be clear, I was going to remove those sentences that were highlighted.
In yellow?
In yellow.
So are you going to, actually that whole paragraph then I think would come out, including the "in these instructions."
And then we would pick up with plaintiffs think the standard instruction.
Well, no, that's just a comment that would come out.
Yeah, okay.
I believe that everything from the "in these instructions" down to the next request, which is the plaintiff's request for an adverse inference, I think that whole 9 yards.
Okay. I am fine removing the two sentences above the written in yellow language.
Right.
Isn't that repeated later on anyway?
Yes.
Yeah, okay, that's what I thought. Yes.
About 9 times.
Okay.
Let me pause it. I'm going to ask Mr. Reyes a question. Mr. Reyes, when I am reading the instructions to the jury, I'm going to want either you or Mr. Cottrell to put them up so the general public can also see them. So I'm going to ultimately have to send you or Mr. Cottrell a copy. Would you need it in PDF form, in Word form? How is going to be the easiest? And I'm going to make it large enough so I can see. So you're not going to be able to put like the whole page, or I guess you could, but
is that too small?
You know, if you want to make it large enough so everyone can read it, probably you only get like a third of the page on the screen at any one time. So how should I send it to you?
PDF format.
PDF? Okay. Perfect. Okay, let's go back to the jury instructions. So this takes us to the top of page 6 in the question for adverse inference. Mr. Elegant, I'm going to let you talk on this, but my working thought is I am not going to give this adverse instruction. So since it's against, I'm going to be ruling against you on this point, give it your best shot.
Your Honor, this is a hold instruction, and really, and from the updates I've been getting, it sounded like there was some question of whether something had been lost, and then, well, maybe it wasn't. But then what I heard late yesterday, it sounds like there's still going to be some documents coming in that are going to be considered by the parties in the court that would show, well, was there something that should be there in terms of reviews or counseling and so forth? And if that turns out to be the case, and they're not there, then we would want the instruction. If there's no factual basis, then obviously we wouldn't request it.
Even if there's no written evidence of those two prior instances of counseling, you already have the reprimand that references those two prior instances. So the fact of those prior counseling issues with respect to Ms. Speedy is already in front of the jury. And I'm assuming that we're ultimately going to get the policy. I think we already put in the policy that talks about progressive discipline. And ultimately, I'm struggling with the concept of, is that really more of a collateral issue? What is that adverse inference going to give as far as a specific cause of action and an element in a specific cause of action? So that's why I'm pretty much against this adverse instruction.
I understand. I think I lack a little bit of I don't know what's going to be. I don't know what was produced last night, or maybe was produced this morning, or is going to be produced. So I don't know what the ramifications of that may be, if anything. So on that factual matter, I think I'd have to defer to Mr. Anderson and Mr. Whitney as to whether this is still in play or might still be in play, depending on what else is produced.
Well, I mean, obviously. And this is why I wanted all the evidence to be closed, so we didn't have to change things on the fly on Monday, but circumstances warrant us not closing the evidence yesterday. So, we might have to make a change on the fly. That won't be the first time we've had to do that.
No, and Your Honor, I think everybody has a word of, if you wanted to take that and set it to the side, and if it's going to come back in, it's easily reinserted with whatever. It would need to be tuned up depending on what the issue, what the missing document was.
For now, I'm going to take it out.
I understand.
And Your Honor, practically speaking, then that will not affect our ability to make the arguments, not for adverse inference, but the fact that things are missing.
Well, Judge, we will be objecting to that. Just experience, but
I need us to stay focused on the jury instructions, and I cannot have us go into 4,000 different permutations of what ifs.
Understood.
We don't have time anymore.
Okay.
I think we're gonna, instead of calling it intentional restraint, I think we're gonna recast it to say false imprisonment.
Yes, Your Honor. I think we agreed to that.
On the title, you mean?
On the title.
Yeah.
And now there's some language within.
In the body, we had used the standard language about intentional restraint, I believe, on occasions, and then it had a sentence that said this claim is sometimes called false imprisonment. There was a time when we actually had false imprisonment throughout because the plaintiffs wanted that, so I don't have strong feelings.
We're good with false imprisonment, Your Honor, and
I think that takes us to page 9. Was the next highlighting that I saw?
And this is just because I'm not really sure on the false imprisonment that I heard any evidence about hospitalization for the false imprisonment for injuries caused by that or the like. And I'm not anxious to have a lot of things where the jury has to think through about, gee, was there any evidence on something? The judge gave me instructions on this. So there are a few of these where I'm trying to narrow down the description of the damages.
And on that one, I'll go to Mr. Anderson or Mr. Whitney. We've removed some other things in other places, but on this one, I didn't know what the evidence was.
Mr. Anderson.
Off the top of my head, I don't recall that the life care plan had actual hospitalization. It did make reference to treatments and possible inpatient treatments. So that may still qualify. I guess we're talking about wording here. I'd like to leave it in simply because of the details in the life care plan.
Yeah.
Okay, but this is with respect to the false imprisonment claim, not your other claims. So just false imprisonment, because I think for other claims, this language definitely is in for other claims. But for false imprisonment
alone,
is Maya Kowalski going to need future hospitalization? Is there evidence that she's going to need future hospitalization, or she's lost the ability to earn money because of the false imprisonment?
The 3 days in the hospital.
Well, the problem we have, and perhaps the court is correct, I'm sure the court's correct, that a omnibus statement of these damages elsewhere would cover it, but obviously this is for a number of things added together that totaled up into the entire harm to the plaintiff.
And that's where we're going. He wants an aggregate damage, and he can't have.
Cruel has a big sigh.
I'm not aware of any evidence, Judge, that's been submitted.
My view of expensive hospitalization, nursing care, and lost the ability to earn money with respect to the false imprisonment, it's not going to come. I'm not going to instruct on it. Now, I will instruct on it in other counts.
Yes.
But for false imprisonment only, I'm going to remove.
Okay, so that's not a huge loss. It's the punitive damages for future hospitalization to Maya required because of her false imprisonment part. So this is that seems to be very small, very minor. It'll be in other sections as well. Quite gingery. Judge seems very no nonsense today. He wants to get this done. He's really frustrated. The schedule has been thrown off completely. We should have had the evidence closed at this point and been proceeding through, but no, we're still open and will be through Monday. And I want to thank all the people who sent me copies of the reports, the IJ finding reports. I've got thousands of pages to read.
The next.
I've got so much
I believe
stuff.
it's the bottom of page 12, top of page 13. It's the same kind of issue for battery. The batteries involved here are Miss Beatty hugging and giving attention to Maya Kowalski that she found offensive, and then the batteries involved in the incident where the photographs were taken.
It's a creative way to describe
Again, I'm not
improper
aware of a lot
contact.
of these damages of hospitalization, medical care, nursing care, loss of earnings of money, that there's evidence that would allow the jury to award those.
Well, I think disability or physical impairment stays in. But is there evidence of hospital or medical or nursing care or ability to earn money?
I think that's a cameraman.
Well, you've got the hospitalization at Arnold Palmer, which I believe we have bills in for. And again, I emphasize, and I confess I don't know this as well. I haven't concentrated on it, but I do have concerns about the defense arguing later, if we take this out, that cannot be included in any further consideration, in any further instructions down the road.
Okay.
Judge, we understand this.
Mr. Anderson, we are sharpening our pencil today. There's no more, we're going to write with a really broad brush. We have to get this done. So I don't recall evidence, and correct me if I'm wrong, that because of the battery, Maya Kowalski incurred hospital expenses, nursing care, or the ability to earn money in the future.
You're right. He's the Alienware guy. For some reason, I thought he was the camera dude.
I cannot off the top of my head.
So, for battery, the hospitalization and medical will be out. Nursing care will be out. And the ability to earn money will be out. The language, when I say out, meaning I will not instruct on them. And let's go on to, let's go to page 14.
That I put in because it was your ruling. I was just making.
I'm so sorry, where?
Oh, on the bottom of page 14, the officers, directors, or managers was the result.
Well, no, before we get there.
Oh, okay.
I want to ask, at the end of the top paragraph, that top paragraph talks about what the jury does if they have found a qualifying issue for us to determine punitive or to consider punitive damages. Do we then need a sentence at the conclusion of paragraph 1 that says if you do not find one of those qualifying offenses, you do not consider the issue of punitive damages? So, for instance,
Yes.
I've sketched out the following sentence, if I can read my handwriting. If, on the other hand, you do not find for Maya Kowalski on either false imprisonment claim or the claim of battery on January 6, 2017, then you will not address this additional claim or something along those lines.
And I agree, especially in this case, since it's only involving 2 of the many claims, that would be a good thing to put in there, yes.
Because I want these instructions to be accurate, but also balanced. If we're going to tell them if something on one hand, but if on the other hand, I think we need to have the complementary instructions.
Agreed.
Yes.
Your Honor, that's fine. And on the verdict form, that's the way they will be directed as well.
Yeah, on the verdict form, we actually we separated them out count by count. It was harder on the verdict form than in the instructions to combine them.
The next additional phrase I'm considering is in the 3rd paragraph, and it's the second sentence, the sentence that begins, if you decide that punitive damages are warranted.
Yes.
We will proceed to the second part of that issue and then add the following clause. After you finish deliberating. So I propose it to read, we will proceed to the second part of that issue after you finish deliberating, during which the parties may present additional evidence. I'm trying to...
I actually thought about putting that language there and decided it was non-standard, so I didn't type it in. But I agree with that the standard would be better with that.
Any problem with that, Mr. Elegant?
No, Your Honor, I understand what's going on. I'm looking at it to see if they're hearing that, what that's, I mean, we all know that if they say yes, they're coming back for a phase 2, and that's what you're trying to convey.
I need the jury to understand that if they check yes on the punitive damages, there's going to be another phase to the trial.
Right. They're going to hear more evidence so they can decide that issue.
Because when these are read, they don't really understand there's not going to be a damage line.
Right. And because there is no damage line, I don't want them to be confused as to, well, do I need to add punitive damage money into a compensatory line item?
And so what is the language the court's proposing?
I wrote down after you finish deliberating. I mean, I'd have to type it in to see if it flows properly, but something along those lines. Okay. And then I was going to leave in the language I had previously said, the officers, directors, or managers.
Your Honor, I wonder if it should say, after you finish deliberating and return the verdict form, I will give you in a few minutes, something like that.
I'll work on the language, I'll wordsmith it, but the concept I will add in.
Yes, I'm just thinking they'll know, because your comment about the comment about there won't be a line on there made me think of that maybe they,
Yeah, so we would like to see something in the event you decide.
When we get a pause, I'm going to read some parts of the IJ.
However you want to phrase that. You will
the
receive
report after the
evidence.
IJ report.
The smoke smell is not a fire. It's just somebody with a microwave too long. Okay.
I was getting hungry. I could smell food.
It's not a fire.
Oh, okay.
It's not a fire.
Yeah, I think it does say right after that the parties may present additional evidence and argument. So
Let me cover it.
Okay.
I think Greg's right, but I think it's there.
Let's move on. I'm going with the second DCA language for definition of manager as opposed to what the defense wants, which is from other DCAs.
I think the defense wanted either one, Your Honor. It looks like that was an alternative.
I'm not going to object and say that one was better than the other. There were two cases and I gave you both.
Well, I appreciate that. Let's see here. That takes us to page, is it 17?
Yes.
The top paragraph. Remind me why this is in blue.
It's in blue because I typed it in and it's my recommendation and I'm pretty sure that the other side doesn't want it. That's why they have the red lines ahead of it. I just felt there's been testimony from Dr. Sally Smith, but there's never been any real, because we're so silent on chapter 39, there's never been real explanation of what role she plays in the CPT and the extent to which the hospital has to coordinate with this. And that's why I put that here in front of the apparent agency part, because it's important that the jury not be confused about that during closing argument.
This is way beyond the evidence.
Well, it's not evidence, it's law.
Well, not the way it's presented.
The first paragraph, I am generally fine with. I think we need to, on that last sentence, remove the word service. So for the circuit.
That's a statutory term, and that's probably confusing, yes.
Well, actually, we probably should change that to zone because that's what the expert testified was the terminology used.
Yeah, I have no objection to a different thing. That frankly, it's always been confusing to me that the DCF circuits and the circuit court circuits are different circuits.
And then I think we need to add in 2016 and 2017 was Dr. Sally Smith.
Okay.
The next paragraph will capitalize child protection team. I was okay with the next paragraph. Now, remind me and talk to me about the excised in the third paragraph, the language excised.
When we briefly discussed this earlier, you had indicated that you weren't bothered about discussing the services in the statute that related to medical diagnosis, but that you felt that the first telephone call had not been made as a consultation under the statute. So there are two references in that statute to consultation. This one that I've left here with the red line excision is one that, I mean, not only do I think it may provide help for the first phone call, but more importantly, I think during what we've heard about the EEG room and all of that, we're hearing conversations that I think also involve a consult. So that's why I wanted that language.
This is the paragraph, as the medical director, Smith was required to be capable of providing certain additional services. Doesn't that confuse what she was doing from the plaintiff's standpoint?
Well, this is taken from the statute as to part of her statutory duties.
Your Honor, I think our problem is how does that go to, I mean, the issue for her is apparent agency, which is not, I mean, it's what the hospital held her out as doing, or she created the impression with the aid of the hospital, and the fact that she has these other statutory duties, in our view, doesn't really bear on that.
Yeah, she wasn't doing those for those reasons.
But for example, yesterday we had a witness on the stand to explain that Sally Smith was in a white coat when she was doing these services, not when she was an apparent agent of the hospital. And that's why we need this kind of thing.
Well, I tend to believe that this blue language is an accurate statement of the law, and it is a instruction that would be required for me to give, so I'm going to give it. The red excised, a child protection team may also provide consultation with respect to a child who is alleged to be abused. I'm going to leave that in. And then in the following paragraph, she was not providing these services as an agent of any hospital. I'm going to leave that language in. Now, when we go to page 18, that's when I start having a divergence of opinion as to whether the balance of those two paragraphs are appropriate. I would rather go back to the instruction I had given in the prior order about the Johns Hopkins. The court's already determined Johns Hopkins made the call to the hotline and they had reasonable suspicion. Whatever the language I used, that's where I'm going to go back to. So I'm probably going to take these two paragraphs out that are on page 19 and go back to the language I previously instructed on.
I think
Your Honor, going back up the line above that, when she provided services in her role as medical director, she was not providing these services to agent of the hospital. I mean, how's the jury supposed to determine that? I mean, that's almost instructing them that she's not an agent.
I tell you what, Mr. Allegate, I'll think about that a little bit more. Ultimately, what's going to happen, it will probably be sometime tomorrow. Hopefully, sometime tomorrow, I will
that's Mr.
circulate
Allegate.
a draft, and then everyone can chop it up.
He's with the plaintiff.
I kind of figure we're going to be working on this over the weekend, probably via email. Unfortunately, I think that's just where we're going to have to do it because I don't have the ability to. I mean, I guess I could convene a hearing on Saturday or Sunday in the courthouse, but you know how unpopular that would make me with all the support staff around here.
I think email works. Your Honor, while we're on this, we're starting to put stuff in from Chapter 39 and so forth. How about one that says they couldn't hold Meyer longer than 24 hours? I mean,
I tried to write that instruction. It's about a page and a half.
Again, when you see what I physically write,
okay,
then you can propose alternatives. But since I'm going to be in control of the document on it going forward, I think it's going to be easier for me at that point because I will know precisely who's made what proposed change, and if I agree, then we can add it or subtract whatever the proposed change is, and we'll go from there. But
for the record, that statute would have given us immunity for a 24-hour window of this, and I tried to write that description rather like I tried to write one for you several years ago on the
Baker Act.
And it just got too complicated to add the 50 pages, so I quit.
Are you suggesting that you can't take what the legislature has written and put it into a instruction I can give to the jury?
On this one for 24 hours, it was just easier to go with unreasonable and unwarranted than to try to get an instruction on that.
Okay, page 18, and this is more a me issue. I have substantial difficulties with double negatives, so we're going to rephrase.
It's an English thing.
In this case, it's undisputed that Dr. Sally Smith was not an employee. So it will probably read something about, in this case, the parties agree that Dr. Sally Smith was not an employee of Johns Hopkins Children's Hospital.
Okay.
It's just, I don't do well with double negatives.
No,
although I use them all the time, but when I'm looking at it or trying to read it, it just is difficult. That moves us to, is it page 20? I'm assuming this is your comment, Mr. Altenburn. For this claim, the medical negligence must have been caused.
Yes, this is not standard, but I realize because we have all of these other claims in here that where you can get these things, that we needed to explain that the traditional medical malpractice is a physical injury.
I think the standard is going to be okay, so I'm probably going to excise this language.
Well, is Mr. Anderson to be able to argue that the medical negligence has caused emotional stress because of various things not related to misdiagnosis or treatment of CRPS?
Well, isn't that for the jury? At some point, the jury gets to decide something.
I'm going to.
At some point, the jury gets to decide something, says Anderson.
Instruction.
He's lost a couple battles this morning, so he's getting frustrated.
Now, I know, and again, and I will preface this when we talk about the negligent infliction of emotional distress, I know the defense does not want this. It does not believe there's evidence of it, and we have that multiple directed verdict motions. And so I've made the decision that we're going to include language in the instructions and the verdict form. So given that we're operating in that parameters, I would not find any waiver by Mr. Altenburn talking about this claim and agreeing to language in this claim because it's clear I have made a definitive ruling. So
thank you.
Is that enough protection of the record so we can just actually talk about?
It is for me if it is for Mr. Elliott.
Yes.
Now, I think what I should do at this point is add the language that is proposed in pink, interacted with Jack. What I'll probably say is interacted with Jack or Beata, Kowalski, or both. I think that's probably a little bit more accurate. On page 23, I think I'm going to remove the statement, "You may not rely on evidence that she heard about an incident from another person when she did not actually see or hear the incident herself." I'm going to remove that. And again, I know specifically that's something that the defense disagrees with. Now, with respect to page 24, I do think that there would be evidence of expensive hospitalization in medical as well as nursing care and treatment. So I'm going to leave that language in. Let's go to page 25.
Your Honor, if I can just
ask burning through this.
The interacted with language.
I'm sorry, what page are you on?
This is the top of page 22. The manner in which it interacted with Jack or Beata or both of them language. If we're doing that and they don't have a physical injury, I guess I'm concerned about what you're going to do in the verdict form for this, because normally there's a finding of, if they're combined, there's a finding of negligence for the first party on instructions on that, and then there's this claim. And I'm only kind of bringing up, I think this creates issues on the verdict.
If you think that we need to have a further interrogatory finding based on the court's ruling on allowing this claim to go, I certainly would be open to that discussion.
And Your Honor, the one observation I would make is, because I know this came up late yesterday on pertaining this, is that, Beata did die. That's kind of the ultimate physical injury.
But that's never been alleged as this or a part of this at all.
I think there's issues. I mean, there's certainly case law that talks about negligence with respect to suicide and how that's very, 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 very limited on circumstances that like inpatient or where there's a duty. And so I hear what you're saying. I'm not sure, though, that the death itself is qualifying, given the status of Florida law on the duty issue and negligence relative to suicide. So, unless there's something else, I'm on top of page 25.
And the problem with this is that this is a special had to be pled, and it wasn't pled for this count.
And what says the plaintiffs?
I thought these were in the initial and repled facts. I need to get my 8th amended out.
My recollection is this issue was not pled for this count. So for now, I'm going to remove. If you can point to where it's pled, I can certainly add it back in, but for now,
Your Honor, if I could, we're on 6C, right? Paragraph 117. These physical injuries and manifestations of psychological trauma included aggravation of her CRPS. Paragraph 117 of the 8th Amendment complaint.
Let me pull it up.
Well, it continues on, weight loss, worsening lesions, and so forth.
This is emotional distress.
At Den, what Den are we at?
As relates to
2816.
He is right that paragraph 117 does say these physical injuries and manifestations included aggravation of her CRPS.
So that stays in?
I was looking at page paragraph 123 in the wherefore clause for something in the request for damages that included aggravation, and
It has to be in there.
I did not see it there.
Okay, well,
Doesn't it have to be in the wherefore?
perhaps when I was looking at it, I was just looking in the wherefore clauses.
I mean, my position is it's supposed to be in the wherefore
Yeah.
clause, but,
Well,
I mean, that's
where you ask for damages. But.
Well,
in an ideal world, yes. But if we're talking about the question of notice, I am now looking at paragraph 117. So I'm going to change my ruling, and I will keep in the discussion of aggravation or activation at this point. Okay.
If the jury goes with the landslide type ruling on this, everything they keep in just adds to the bottom line, the bottom figure that's going to
Now let's move on to
if they piece it out and find for someone and not for others, it doesn't make as much a difference.
Issue. And I guess has the plaintiffs changed their position at all on this, or are they still riding this horse?
I think we want to ride this horse a little longer. And there's always JNOVs and other ways to deal with it, Judge, but I remain concerned that you never know what you don't know.
Well,
I will defer to the. Sorry.
I have detected a shift from negligent training of doctors and healthcare providers to a more generalized staff. So let's talk about that, because my inclination is to keep it to as it was pled, which is more along the lines of negligent training of doctors and healthcare providers.
Your Honor, staff was pled, and again, I didn't hear this part of the testimony, but the reason we added it in here is because I understand there was some contention made that Ms. Beatty was not a healthcare provider, but was just staff.
Okay, well, can you give me a paragraph?
Oh, where staff is pled? Yes.
In this count, there were references to staff, but this count was this thing that had several different theories in it throughout. And that's been the problem when they started dropping this and dropping that. And, you know, negligent training of doctors is a medical standard of care. Ms. Beatty is a professional, but she's not a healthcare provider.
She's not.
And I'm not sure, I haven't heard anything, there are complaints about the people in the cafeteria.
Well, and then let me, and I know this is forecasting what's going to happen on Monday, but based on the discussion yesterday, if this joint commission finding of whatever it was, immediate jeopardy, and I think Mr. Whitney told me yesterday that the finding was based on a systemic issue at the hospital having to do with patient safety and organization, and
this is just a tease.
Stuff that was not just failure to, he might have even said that there was a failure to train folks at the hospital as discussed. I mean,
he did those opinions. I agree. I heard it yesterday. I don't think it should have come in, and all that discovery was done because you allowed it for evidence on the punitive damages claim at the end of the summer. This wasn't done because they needed more on this claim. They were ready to go to trial on this claim, they said, a year ago, April. And so I was listening to that yesterday trying to figure out what it was really relevant to.
I don't want to get into it because there's so many issues associated with it, but if this report comes in or some discussion about the report, I'm having to, in my mind, envision how the jury instructions are going to look and what the evidence is going to be. So, you know, I'm somewhat handicapped because I think all of you know exactly what's going on, and I'm the only one left in the dark. So
we have a pretty good idea now, Judge, but we still await the defendants providing of documents that
that's
we're supposed to receive.
Supposed to happen this morning, and then the deposition is going to happen tomorrow.
That's correct, Your Honor.
Yeah.
The documents will be given this morning.
So,
wow,
I'm just in my mind having to formulate what the possible evidence is and how it impacts. And out of everybody in this room, I'm probably the one with the least amount of knowledge. Maybe, Ms. Krause, you probably don't have the same knowledge as everyone else. But
I have some knowledge.
I know some,
I knew about it too.
but probably not the deep history on this issue.
She probably has more than I do.
Well, yeah, you probably also, Mr. Altman, probably don't have it. Mr. Elegant probably doesn't have it. But
it's Mr. Shapiro.
I'll confess.
Mr. Shapiro, Mr. Hunter.
Your Honor, while we're on this staff thing,
deep.
Paragraph 193 and 14C incorporates some earlier paragraphs, among them 170, which is a part of 14A, and 170 refers to competence of its medical staff and personnel. So, you know, again, we did plead staff. Plaintiffs did plead staff. And again, it continues on later when we talk about staff and some subsequent allegations that are incorporated. So that's why that came in. And again, I think I just heard this morning that she's not a healthcare provider, she's staff. So
we're sitting
she's
here.
never been a healthcare provider.
For the record, we moved to collapse the pleadings into the proof on that count.
But we're sitting here at the end of trial. Everyone has rested, and the plaintiffs have not provided something that would provide a training theory for the doctors as professionals under a medical standard of care by the medical committees that you believe may be responsible for this, and a separate one for staff who are negligent, and they're citing cases about employees who are outside the scope of their employment or otherwise someone's not liable for as an employer. So I just don't know where to go with this, so I'll stop.
anything else, Mr. Elliott, that you?
Your Honor, I have no problem with putting some language in, if it's not already here, that says, you know, if you're looking at the medical, you know, please refer back to what I told you about medical malpractice standards. You know, there's no problem with that.
Well, for now, what I'm going to do is keep in the reference to staff.
That's big.
And if
that's a big win for the plaintiff, if they can keep
someone has objection to the language that I send around, hopefully tomorrow, I'm confident that you will, in legislative format, showing the strike-throughs and additions, any sort of proposed changes. I think on page 26, I was going to leave in the pink language.
I do not have pink language.
Oh.
It's shaded on ours, I think, Mr. Anderson. We did lose.
Yeah,
It looks pink to me, but
the pink is only because I put a comment off to the side pointing out that I thought it demonstrated the problem with the whole concept.
But it's right now I'm keeping that language in.
Yeah.
And then the highlighted on page 27 in yellow, and pink and yellow, I was going to leave in, and I would leave in the staff reference as well. So I think that takes us to
Shapiro, Hunter, and Whitney are all working this IJ issue right now this morning.
the fraudulent billing.
Yes.
But I mean, your comment was, I took it to mean, you just disagree, but now that I've ruled.
Well, I think the comment maybe reads longer than I've got that it's on the screen. That not only they failed to prove, but I mean, yes, his policy that year came with a deductible, and when he was on the stand, he was asked about whether this deductible would have been paid for all the other things that went on in his family during that year, and he had no idea. And from looking at the Aetna run that's 900 pages long for these 3 years, it looks to me like even if you cut out all of everything from the hospital, the deductible was going to be gone. So there's no evidence that there was a deductible that he was damaged by, and he produced no payment whatsoever of a copay from any account, nor did he claim that he took it out of his billfold and paid it that way. So that none of that is here.
I understand that you believe that this claim shouldn't go. I know that. I've ruled otherwise.
Okay.
But so the comment, I think, was more of a renewal of the DV motion as opposed to an alteration of the
That's
language.
correct. If there were proof of all these things, that they could be on those lines. And but on the, I'm not quite sure what we're doing with the lien. I agreed that they didn't have to prove damages of that, but I don't know what the jury's going to do if they get a decision about any increase in insurance carriers' lien rights against the plaintiff. How are they really supposed to do that?
Now, on page 30, where there was about 8 comments, that's kind of where I started getting lost in what you all are trying to say. So let's talk about page 30. So who wants to go first?
Your Honor, I think this isn't quite traditional, but I think in terms of dealing with a lien and the amount of a lien and so forth, that number C, that is something that we understand the court would typically do after the fact. So in terms of that part, I think we're okay having subpart C come out.
Let me answer a question. I'm going to turn them down just for a minute. I don't
the pink
often do
language in
this.
A and B.
Well,
but
we were just talking about that.
I'm going to turn this down just for a minute. A lot of people are here talking about the IJ, and that is the elephant in the room. That it's a huge issue that's going on. There are things happening outside of court regarding the IJ today. Specifically, the judge has ordered that all those documents, the original report, that's what they're going after. I think the defense will not provide that original report. I think they're going to stall on that and try something else. But the judge has ordered those documents should be turned over to the plaintiff. There is also a deposition scheduled for tomorrow regarding the hospital expert.
Not going to be as crisp.
Let's see here.
Because this is later in time, and I've somewhat run out of time in my prep. So
That's okay. And
I think we're going to
probably need to discuss.
We're going to have more discussions about the next few comments.
Anyway, so tomorrow's going to be the deposition of the hospital official talking about those things. That's going to be with both Mr. Whitney and Mr. Hunter, probably Mr. Shapiro there. Mr. Anderson might be there as well. The outcome of that is going to be presented to the judge Monday morning, and that's when the judge rules on this. He's already sort of tentatively said, I'm trying to get my head around how we're going to phrase these jury instructions if this is what I think it is, which he's leaning that it is. He's believing Mr. Whitney that this is what it is. The indications I have seen is that the judge is right, Mr. Whitney's right. So the big IJ decision is going to come on Monday. We're not going to have fireworks right here about that in court. We probably won't even see Mr. Shapiro, Mr. Hunter, or Mr. Whitney in court today. They're just going to handle this, the jury instructions. So it might be a little slow today. There's going to be some dancing around this and some references to the IJ. We're going to cover a little bit of that during the breaks, or if they end early, we'll recap some of that. But then Monday's going to be the fireworks, because Friday they're off.
So that's a wrongful death, not
That's the wrongful death. That's
so
not.
I'll put that to the side. And
yes, there's no change in what. And here, what I pointed out is, if there's been all kinds of evidence in this case about maybe a negligent violation of the statutory Bill of Rights language, or some internal policy, or that we didn't put her name on a door, and all of these things that they're being complained about, but they're not things that, if analyzed, would go to a jury as extreme and outrageous conduct, without regard to whether it wasn't even intended to create severe emotional distress on the part of Beata Kowalski. And so, because there's so much of that in this case, there needs to be something that explains to them that there are some things they can't consider for this, and a better description of what they can. And this was my effort to do that, because again, normally there's an incident, something that's a big trigger event that causes this in the case law, and this case doesn't have the big trigger. It's just got things going on for 100 days in the hospital.
Mr. Elliott.
Your Honor, my comments are there in red that, this is, I think the jury hears this and they're going to basically hear the court telling the jury, there was just no big deal here. This was stuff wasn't important.
Well, Mr. Anderson, I can only have one person talk at a time.
We just think, these paragraphs are jury issues.
It is all contextual is the problem, Your Honor. It's all contextual. Any one of these things, pulling isolated facts out of a storyline and saying, well, we just think because we're, I guess, not the jury, that we should ignore this and then you should ignore that. This is completely and utterly for the jury to decide, and telling them what they should consider to be outrageous under those circumstances is invading their province. I object strenuously to anything that does that.
So let me point out.
And this is a rather key count.
Yes, and this is a key problem.
That's the negative inference.
Let me just use one example, if I may. The lady that my partner here so nicely explained had a nice hat. She came into the hospital and didn't register and was bringing this semi-sanitary icon into a hospital room. Let's assume that was negligence on the part of the hospital to let her get in. But
they talking about the Christus?
You can't take things that aren't themselves extreme and outrageous conduct. You can't take 14 little negligent things and say, oh, that equates to an extreme and outrageous conduct that intends. That's exactly what they're trying to do. This whole context is to tell this long story made up of things that individually cannot possibly qualify for this, and then say, well, but if you put them all together, somehow they become an extreme and outrageous conduct. And that's just not the law. And the jury needs to know that.
I thought we had this decided when the court ruled on the directed verdict motions and on the summary judgment motions on these exact same arguments.
It was found that there was sufficient evidence of extreme and outrageous conduct to go to a jury. I just think that there's a pile of things that aren't that they need to understand aren't that.
Because, yeah.
Folks.
Yeah.
Give me a chance to reread this, please.
Yes, sir.
Okay, I have not finished my edit of the sound. I want to cut the words and play them back and forth and alternate so you can hear words, the similar words, the honey and the I want to put mix and match and play back and forth. And so we'll have that coming.
Let me tell you where my head's at, and then I'll let everybody respond. Out of these 4 paragraphs in blue, I think I would go with the defense request number 3, but not 1, 2, or 4. So my current thinking is we would only instruct as to paragraph 3, which would include that sentence or that fragment of a sentence that is underlined as well. So that's kind of where I'm at. So Mr. Altenburn, why don't you?
Your Honor, I mean, the whole reason I put that paragraph in was because I didn't want what's in the underlined language to be sent to the jury as an explanation. I mean, if you're going to add the plaintiff's language to that paragraph, I'll withdraw the request for that, because things that were relayed by her, things that Maya Kowalski told her father that may or may not have been entirely accurate, she's 9 years old and upset, that he takes home in this game of telephone tag, and he tells his wife, and he can give us a general description of it, but we don't know exactly what we said, and we don't really know how she responded on that day because she's never been able to testify about that. How can that be evidence that makes the person in the hall that was doing these things that got them upset, that's extreme and outrageous conduct intended to cause Beata Kowalski severe emotional distress? This telephone line is the exact reason why a lot of this stuff can't qualify for that. So if you're going to add that language, I just want to, if you're not giving the rest of it, I would withdraw it all.
Mr. Elegant, you heard my thoughts that I was thinking about doing 3, but with the underlying. Now also qualify that with Mr. Altenburn's request to not have it at all.
We're fine not having it at all. I mean, Your Honor, all the extreme stuff is defined immediately above that in 410.4, 5, and 6. I mean, it's all covered how bad it has to be. So we think the standard instruction covers it.
As long as Mr. Anderson doesn't argue that he can take 9 negligent acts and turn them into 1 extreme and outrageous act, that's fine. But he's not going to argue that when this case is closed. So, I mean,
I'm glad
to
you're
make it
writing
clear,
the closing for me.
Well, I've heard your trial.
You can say all sorts of things in closing.
Again,
you really can.
I want these, but if that's the ruling you're going to make, I'm going to have to say that I have to withdraw them, because it's worse to give them with that than to have them all denied.
So
agreed. Withdraw.
So given my ruling that I would do the number 3 with the inclusion of that underlying clause, you are saying you want me to remove number 3, and it sounds like the plaintiffs are okay with number 3 being removed.
They're okay because they're going to argue that altogether is extreme and egregious. And now he gets exactly what he didn't want to have happen, and Mr. Anderson is like, that's where we're going. That's what we're going to say. Thanks for writing my closing.
Disagreement as to that last paragraph?
Oh, the final language is that I don't think the concurring cause language that's standard, that they gave enough thought to this being a stress case. And so the language extreme and outrageous conduct may be a legal cause of severe emotional stress, even though it operates in combination with the act of another. I think it's clearer to the jury to say, even though the act of another or some other cause also contributes to the stress, because I think that's what they're trying to explain.
We want to stick with the standard language.
Mr. Elliott?
Yeah, Your Honor, as my note on the side, as Mr. Anderson says, we want to stick with the standard. I mean, I quite frankly don't, I mean, grammatically it's different, but I'm not sure how much different it is in meaning.
Okay. Well, I'm going to stick with the standard.
Okay.
So we're not seeing everything
On
they're
page
looking at, so it's a
33,
little confusing right now.
The pink box.
Unless they announce what they're talking about. But
Am I reading that the parties agree?
Let me.
I'm going to switch sources really quickly.
I'm sorry,
Pink
Judge, where are
box.
you?
Which page? Judge?
Page 33, under the instruction, which is 410.7.
Oh, yes, Your Honor.
The phrase, during the time that Maya Kowalski was a patient at the hospital.
Yeah, I think we all agree on that.
Yes, that's good.
The side note says that Mr. Elliott says it's okay.
And I do.
We're going to the intentional infliction of emotional distress, wrongful death claim.
Oh, good. The other feed just dropped completely.
Unless there's anything else on the survival claim.
Perfect timing.
No, I think that's right. And as Mr. Altenberg noted, he sent some stuff over this morning that it kicks in at one point here, and that may be easier than trying to work through some of this once we get to that point.
I agree.
Well, it looks like that starts at 410.7. So
I think so.
I had made the same request on concurring cause, so I'm assuming you're going to stick with the standard language here as well.
I'm going to go with the standard.
Okay.
So does that take us to 410.7 or?
Yes, I think it does.
I think so. Yeah, I think all that stuff in red then comes and it all comes out. Everything before from there on down to 410.7.
For the record, I had wanted what is in the current instruction, but once there's a ruling that it has to be dual, it just doesn't work. So
let me
try to put this
reread
together.
this alternative language that came in, I guess, at midnight. Just give me a second to read it again.
Yeah.
So if they find no on that, then go.
Whoa. Okay, sorry. I'm distracted a bit. I'm ordering a camera. I'm ordering one of the cameras that's being used in the courtroom here. It's a pan-tilt zoom camera. And I just ordered it, and they gave me a super deal. But they didn't say they were going to do it. It just showed up as a deal in my inbox. All right. While we're talking about this, yes, squirrel, yay for super deals.
Mr. Altenburn, is there anything that you want to tell me about this language? And I'll go to Mr. Elliott as to his thoughts about this language.
Well, at some point, I do want to explain to you, why it is that I think we need to have more on foreseeability if we're using the substantial factor test and explaining in a little more detail why I still believe that's a mistake. Because until your ruling in open court earlier here, I had at least assumed that we were making a substantial factor meaning irresistible impulse, and so it won't take me long to do it, but I need to try to do that.
Sure. Go ahead.
You want me to do that now? I'm happy.
Might as well.
Okay. So I've cited the cases we've discussed before and taken quotes out of them. And so in describing these the case law always goes into the importance that there's qualitatively something different about foreseeability here as well as causation of suicide. And while I don't actually, I've gone through a laundry list of options with you, all of which have been rejected about what the intent should be, but we're down basically now to the remaining irresistible impulse is more or less the same language that the plaintiffs requested initially out of Nelson. Nelson is under FELA, minimal negligence language, but it's the only thing we have in Florida. So if we're going to use that, I've tried to put this in here in the context of a tort that is designed to only hit suicide on the rarest of circumstances, which FELA law is if there's any negligence, you win. So that language has been adjusted there. But the problem with the substantial factor test, and I was thinking about this last night, but as an example, I have an uncle, Edward Gamm, Mondayman, Iowa. He was a good Catholic. He was a husband. He had 2 boys. And many years ago, he committed suicide. He had been on a crew of a bomber that got shot down over Germany during the Second World War, and Adolf Hitler's army put him in a concentration camp for an extended period of time. He did not commit suicide until many years thereafter, but I will tell you right now that I believe that Adolf Hitler's army was a substantial factor in the suicide of my uncle, and I will believe that viscerally until the day I die. That's an emotional feeling on my part, and maybe somewhat moral feeling on my part, but it's not a legal duty. And the reason that we have made suicide something that we place the duty upon the person who does it, that we make it an independent intervening cause, is because there are many public policy reasons to do that. The legislature hasn't recognized this tort, and so far the appellate courts of Florida have not. And there are reasons we do that because, again, I checked last night, the CDC estimates that in 2022, there were nearly, I think it was 3,400 suicides in Florida. I guarantee you that
he's prepared the speech.
At least 2,000 of those families who lost a loved one will tell you that they're not going to tell you, well, it was all his fault. He did it. It was an independent intervening cause, and it's all over. As human beings, the first thing we think about when someone commits suicide is, well, what caused that? What was the trigger? Why did Mr. Bill do that? And that's, I think, good therapy for us to try to search for those things, and as from a preventative standpoint, something that the government should work on to try to keep people from committing suicide. But the Kowalskis clearly think that DCF was a substantial factor. They think our client was a substantial factor. They even probably think that Judge Hayward was a substantial factor. And I'll tell you clearly on the record that Judge Hayward played absolutely no part whatsoever in what we're dealing with in this case. But if we have an instruction that goes to the jury and, that says on the verdict form, we've modified this, that
I don't understand his argument based on his personal story. This is crazy.
Did Johns Hopkins All Children's Hospital, through the intentional or reckless acts of its employees, engage in conduct was sufficiently extreme and outrageous that it caused Beata Kowalski, excuse me, I'm reading the wrong one, that did the employees commit extreme and outrageous conduct that was the legal cause of severe emotional distress that was sufficient to be a substantial factor in Beata Kowalski's suicide? If we ask the jury that, just like the 2,000 families who have to believe that it was something else that at least something was a substantial factor, that's the analysis they go through. That isn't the law now. It shouldn't be the law. And so I believe that we should not give this, but if we do, we need to emphasize at least that for the law, this has to be something that's foreseeable, where the person can say while they're doing the conduct, yeah, you know what, this could cause him to commit suicide. So what? That's reckless disregard. But unless we have something very, very strong on this, when we give them this thing on the verdict form, they're going to do exactly what those 2,000 families did last year in Florida. And we'll have lawsuits down the road, not just this one now that's the first in Florida. We'll have lots of lawsuits about this if this becomes a law. So I want a jury instruction that's as strong as possible, at least. Even though, frankly, I guess if one is weaker, it's better for me on appeal. But I feel obligated to get one that's as strong as possible.
Mr. Elliott, on the comments that Mr. Altenburn just made, any response?
I'm a little unclear. Was that going to the part that talks about the second test you will apply?
Yes.
Yes.
Okay. I don't think we have a problem with the wording of the paragraph that starts the second test. I have some issues with some of the stuff above.
I guess I'm talking about the more generalized comments that Mr. Altenburn, before we get to the specific language. I mean, he's looking at this, and his argument was at the conceptual level.
Well, yeah, we talked about that before, and I mean, there's some things that I would do differently. I mean, we had talked about whether it could be a rational decision or not, and that's not in here, and I'm not going to ask for that. I mean, I suspect we've all been either families or friends that have been touched by suicide, and it's a tragic situation, and it's but I think here, I mean, the jury will decide if it was a factor or not, and I don't think it's automatic. I mean, it'll be based on everything they've heard. So. The way the verdict form is going to be broken down, we'll have to see what the exact questions are, but there's going to be one question for the irresistible impulse, and there's going to be one question for the substantial factor. And so later on, and I think you already said this yesterday, later on, if the appellate court decides it's one and not the other, then they'll have the guidance to sort through that. So.
Okay, this is crazy. I want to tear this apart just a little bit.
Let me just make a couple of observations about Mr. Altenburn's comments, and then we'll get to the specific language.
He researched
what I'm hearing Mr. Altenburn effectively make is basically a slippery slope that we're going to open up the floodgates to and basically energize a previously almost dormant cause of action. And under that cause of action, we'll now recognize a whole panoply of situations that previous to today, Florida law didn't recognize. I think I just want to push back and disagree with the fundamental premise. First, we're talking about intentional conduct, not negligent conduct. The case law already builds in a check on the issue of whether the conduct itself is appropriate for taking it to the jury. As we all know, under the Stedman case from the second DCA, the element of outrage is an issue of law. And I think that's a very important safety valve in the intentional infliction of emotional distress, because it allows a trial judge right at the beginning of the case on a motion to dismiss can weed out any claim that does not rise or doesn't plead facts such that the conduct does not meet the intentional standard, the outrage standard. For instance, when I was assigned to the parents of the Gabby Petito versus the parents of Brian Laundrie case, the very first motion that I heard was a motion to dismiss the intentional infliction of emotional distress on a claim that the facts did not rise to the level. And obviously I disagreed and I denied the motion to dismiss, but the point is the check of the emotional or the conduct is something that the court can address right off the bat. You don't have to do any discovery on it, and it doesn't open up floodgates. So I just would push back because I think the existing case law already builds in the protection against what Mr. Altenburn is effectively trying to argue. Now, it breaks my heart to hear what happened to your uncle, Mr. Altenburn, and there are countless number of families, both in that war and other wars where there's just brutality. I actually would consider what Adolf Hitler did to be probably the most outrageous I've ever seen in recorded history. So I think his conduct would qualify under Florida's intentional infliction of emotional distress. And, you know, under a substantial factors test, I think your uncle perhaps would have had a cause of action against the Third Reich and Adolf Hitler. But that is besides the point. I do believe that Florida law does recognize the substantial factors test as well. And so I do believe we're going to keep it on, or we are going to keep it on. So having said that, let's get to the specific language.
Let me, as they do that, let me explain a little bit of background here. A background on why we just had
specific language.
Mr. Carroll, Judge Carroll, be so respectful in his response to Mr. Altenburn, sort of from left field argument. I'm going to give you that as soon as we get a break. Don't let me forget. There's a lot of backstory.
Did not need to specifically intend the conduct of its employees to cause Beata Kowalski to commit suicide. So I've placed that there. I then say that, however, the employees of Johns Hopkins Children's Hospital needed to engage in extreme and outrageous conduct with the actual intent to cause Beata Kowalski severe emotional distress or with reckless disregard of the high probability of causing Beata Kowalski severe emotional distress. I put that in there because we jumped from a finding in the previous count. This instruction doesn't have the issue language about the intent to cause the severe emotional distress, and especially if we have the sentence about what it is they don't need to intend, we need to repeat what they do need to attend.
Do you mean and act?
Extreme, and she says I mistyped something here.
However, the employees
to engage in extreme and outrageous conduct.
And?
Yeah.
Missing a word and? Is that what you meant?
Yeah, the act should be and with the actual intent.
Okay, and.
And with the actual intent. And I believe that's a correct statement. And it should be given. And then I jumped to, in most circumstances, the law treats an act of suicide as unforeseeable and requires the person to be responsible for their own act of suicide. That's a true statement of law, and once we're going to jump to this one, I believe they need to understand that this is an exceptional circumstance, and that provides that. So as a result, in order for the hospital to be liable for the death of Beata Kowalski, you must find that her suicide was a likely result of conduct of the hospital's employees, which is probably more generous than I would like, but I think that follows the turquoise language, and then I follow this with there are two tests that you will apply to decide this issue. First, you will use a test called the irresistible impulse test. I'm explaining this a little bit more because it's unusual to have two tests. I think they need to understand that. Because responsibility cannot be placed on someone for a suicide committed by another person who could reasonably be expected to resist thoughts of suicide, this test requires you to find that Beata Kowalski committed suicide as a spontaneous decision brought on by an overpowering urge or desire. And that is right out of the standard English language definitions of something that is an irresistible impulse.
That irresistible impulse is very difficult to prove.
The extreme and outrageous conduct must have driven Beata Kowalski beyond the point where she could rationally decide against killing herself on January 7, 2017. And that's based on the language that actually the plaintiffs requested earlier out of Nelson. The second test you will apply to decide this issue is called the substantial factor test. When someone causes another person to suffer from severe emotional distress, that stress is not always enough to make the person who causes the stress responsible for a suicide committed by a person who could reasonably be expected to resist thoughts of suicide. That sentence is too long, but I couldn't manage to shorten it last night. This test requires you to find Johns Hopkins Children's Hospital is responsible for Beata Kowalski's suicide only if you find that the severe emotional distress created by the conduct of the employees of the hospital was a substantial factor in bringing about her suicide on January 7, 2017. I've not included a definition of a substantial factor in this. I suggested some before, but frankly, they all went back to irresistible impulse. But I do believe that if the court is going to do this, there ought to be some definition of a substantial factor. From the case law, I just didn't quite know what to do.
Mr. Elliott, anything?
Yes, Your Honor. I think we're fine with the first couple paragraphs. I would say my main concern is the words in the fourth paragraph, the paragraph that starts there, two tests, where it refers to a spontaneous decision. That we don't see that in any of the case law, and really logically it doesn't make any difference. If these things happen over time and it builds up, I guess the decision when you ultimately do it is always spontaneous. But the concern we have here is that the defense will go in and say, "Oh, well, look, she thought about this for a day," or "There's evidence she thought about it for a day," or whatever. That should not relieve a defendant. If the defendant does cause it, or they are a substantial factor, or they lead to it, that should not relieve the defendant because the person waits a day or some period of time. So the spontaneous decision we really object to. The paragraph that starts "in most circumstances," I mean that's basically just telling the jury some law. I don't know, and it's sort of repetitive of what comes after it anyway. I mean, in order for the hospital to be liable for the death, you must find her suicide was likely conduct of the hospital's employees. I don't think we're offended by that, although it is, again, repetitive. I mean, they're told several times in this and above it that the hospital has to have been responsible or been a contributing, substantial cause. So I think those are the main concerns I have there. As far as trying to define substantial, as we pointed out in the other set, I mean, the standard jury instructions, they say in the comment, we use substantial because it's a commonly or substantial or substantially because it's commonly understood. I don't think it needs a further definition. I mean, obviously we could look at, something, but I mean, I think it speaks for itself. And there's, they even cite to like a really old case that came out the year I was born for the definition, or the reference.
In response?
Let me tell you what I'm going to do, and then I'm going to give everybody one last chance to say anything. When it comes to the intentional infliction of emotional distress, wrongful death claim, I'm not going to announce. I'm just going to adjust the language and send it out. I think it's going to be easier for me to do it that way than trying to articulate here with all these different pages and whatnot. But if there's anything else you want to tell me about intentional infliction, not the damages, we'll talk about the damages in a second, but the actual
Can one of the mods post the link to Jules'
damages
TikTok?
on IED, wrongful death, then go ahead and say it.
I have responses. Listening to his argument on the third paragraph, what he's really saying is he doesn't want you to read the sentence. In most circumstances, the law treats an act of suicide as unforeseeable and requires a person to be responsible for their own act of suicide. A, that is exactly what the law is.
Let me get it for you.
B, it's critical for this jury making this decision to understand that that's normally the law and that they're working on an exception to the law. So I believe that that's very important.
Thank you, Samantha.
as far as whether an irresistible impulse is spontaneous, that's what Webster's dictionary says it is. When you go by the candy store and you just can't resist going in to buy the candy, it's an irresistible impulse. And this is a very different circumstance, but it's still the same. And moreover, their own expert, who I keep wanting to call Dr. Roberts, but his name is Dr. Richards, said that most suicides are triggered by an event that occurs within, I think his number was, the range ended at 72 hours. And so even their expert, I'm not sure where spontaneous ends, but says it's something that occurs because of a trigger that takes place in the near time period of the suicide. So maybe there's a lesser word than spontaneous, but the notion that it has to be something that isn't thought about for a long period of time is there. I mean, this woman wrote apparently 2 drafts of a suicide note, and then another one. We have 2 sets of these in, and she put together an elaborate way to do this. And the jury needs to know that that's an important concept here, because in trying to decide whether she could resist thoughts of suicide, she did an elaborate plan. So this is very important. And then on the definition, he's talking about the definition for concurring cause. And I've given you a memo. I probably have memoed you to death, but that has to do with damages rather than the causation of something like suicide. And so the fact that we have used it for many years in a combined jury instruction that was intentionally designed by that committee. I was on that committee. I know what they did on that. This is a case where we need something separate and distinct for the causation of a suicide as compared to the damages that flow from that suicide.
And on a side note, there was discussion a couple of weeks ago about not using the word irresistible, but I think it was uncontrollable.
Uncontrollable. I would still prefer that, by the way.
Yeah. So, Mr. Allegate, anything further, and then also maybe commenting on the word uncontrollable instead of irresistible?
Nothing further. As far as the words go, I think the case law that we were referring to uses irresistible.
I know that the case law says irresistible, but
actually it's a mixture. Most of the cases that are under this intentional infliction use uncontrollable, but the FEL case that started it uses irresistible.
And I just wonder if the word uncontrollable is better understood than irresistible.
And in particular, because their expert tried to turn it into a psychological concept, I'd still believe uncontrollable is the safer word to use.
As long as we don't end up with the defense then arguing that our expert did not testify to that specific term, but rather irresistible.
Well, to me, the words are synonyms.
It is. I just didn't want there to be inevitable motions or objections coming from that judge. I'm fine with either one, but I tend to agree with the court that uncontrollable probably defines it a little bit better under these circumstances.
Okay. Anything else?
Okay. Sounds like I think Mr. Altenborn wanted uncontrollable also, right?
Well, I mean, I'm at this point,
he doesn't want to claim.
I get that, but
as long as it doesn't change what it takes to be, it still needs to be a spontaneous thing that you do in this fashion. So I'm not changing the language other than you can change irresistible to uncontrollable, but the rest of it is what we need to have.
I think irresistible would be a higher bar to set for the defense.
Let's talk about the damage component. I don't think there was a disagreement as to the damage, but just want to make sure.
I don't think there was either. I talked to him on my computer.
You lost battery?
Yeah, no. I had to go back in and do the safety check on it. So, okay, I'm ready now.
So there's no disagreement as to the survivor damages?
I believe that's all standard language and accurately entered at this point.
Okay.
I think so, Your Honor.
Let's see if we can get done here in the next
little bit.
And the next
issue is on pages at 43.
We've got so much to talk about here in just a minute. We just need a break, and we don't get any, apparently.
The primary contribution language again?
That's the only thing was that the objection you have denied a couple times.
Yeah, I think that's probably coming out.
Well, and then finally on page 45, for the one with the Ayden Kowalski, it's not so important because it's survival damages, but 501A2, which they put in here, starts with any bodily injury sustained by, and that's really kind of backwards of this tort because.
Okay, I'm sorry. So we're on Maya's IED claim now?
Yes.
Okay.
And it's page 45 of the top paragraph. You award damages for any bodily injury sustained by Maya Kowalski and any resulting pain and suffering. Well, this tort actually reverses those things because it's a tort for creating emotional distress. So it ought to be for any emotional distress and for any bodily injury. I mean, if they proved it, which I'm not sure they did, any bodily injury resulting from that would be what would happen.
Kind of like a physical manifestation stemming from the stress?
I'm not sure. I'd like to see the language and think about it, but this language is not it.
Yeah, I don't.
Mr. Elliott, any thoughts?
It's an emotional distress.
I don't think I have anything to add on this. We took out a reference to disfigurement as not being within the evidence. I don't think I have anything.
Is the issue here whether bodily injury stays in? Or?
No, whether it comes before or after the mental anguish, I think.
I think it's how to phrase it.
Yes.
And I'll think about it, and you'll see what I end up doing hopefully tomorrow.
I would hope and or bodily.
Well, okay.
So
that takes us to 47.
Yeah, and that a highlight was only I wanted to show you where the lawyer talking to witnesses is, and so it's going to be on page 47 in that spot because you didn't want to put it up front. And then the blue language is non-duplication language. I wasn't sure where to put it, but that seemed like it. Initially, I tried to put it up front, and that didn't seem like the appropriate spot, so I put it here. There's no standard language on this, but I've used language very similar to this on a number of occasions in the past.
How are we going to how is the jury supposed to take this when we are separating out damages for individual torts and be able to accurately comprehend where one starts and the other one stops? I do not agree with language other than a very general statement to the effect that
this is a pretty general statement.
Should not.
Well, I'm open to something more specific, but we've got false imprisonments and batteries taking place simultaneously, for example, and his whole goal is to maximize the damages by getting them to award multiple things over and over again. And these things, hospitalizations, every time she goes in the hospital, it's going to be for all of these things, according to him. And so they have to have non-duplication so that they think through the fact that if we awarded hospitalization or lost wages for this last claim, how does that impact this claim? Because they go through this series by series.
I was always for the idea that if you took a set of damages and if any one of a series of causes of action awarded the same damages, you had those damages. The decision has been made. We're going to do it separately. I do not want the jury out there confused about, well, we awarded this much for this. Now, how am I going to separate the mental anguish from this? It seems like an impossible
Mr.
task.
Anderson, I need to rein you in, man. This is appellate talk. This is not in front of a jury talk. Let's just get this. Conceptually, I'm okay with the concept of non-duplication. I'll look at it a little bit more, but I think some sort of statement that Mr. Altenburn is suggesting is probably appropriate.
And I'm wide open to any alterations or changes you want to make on this because, again, it's not a standard one, and this case is more confusing than normal because there are so many claims.
And Your Honor, I would note that in the jury instruction, or excuse me, in the jury verdict form, I think we have a couple different ways of wording it maybe, but we have a non-duplication instruction in the verdict form.
Yeah, I've seen that. So is there anything else on the jury instructions? Because I think that was the last one that I saw.
Not to my knowledge.
Just to the best of your ability, you should avoid duplication or something to that. Okay.
I will have some sort of non-duplication instruction in there because I think it's important. And I think the jury needs some direction on it. That being said, I think we have now dealt with the jury instructions. Our next task would be the verdict form. I would propose that we take, a 5-minute or so break since we've been at this for an hour and 45 minutes.
Okay.
Any objection to?
No.
We have unanimous agreement that we're going to take a break, 5 minutes.
Okay, as they take a break, I want to talk about a couple things. First of all, going way back. We've all heard that Mr. Aldenburn was the judge's boss, that he did appeals for, and sort of like oversaw cases that were appealed from Mr. Carroll's courtroom. It starts way, way, way before that. This starts with a court case in 1992. In 1992, when Judge Carroll, then a 16-year-old Mr. Hunter Carroll, appeared before Judge Aldenburn in a family court case where the decision that was being made was, should his dad, who Mr. Hunter refused to go visit at 16 years old, should his dad have to continue to pay child support? And Mr. Aldenburn presided at this case. This is 1992. The judge ruled that he did not have to go. First, I believe the previous judge ruled that he did not have to go visit his dad, and that previous court had also, in the same time they did that, of their own volition, stopped any child support payments to his mom. And Mr. Aldenburn basically restarted those payments. Okay, so that goes how far back this relationship between this judge and the defense table has, how long they've been together, how long they've seen each other. And then as he grows up, okay, he decides to be a judge. Could it be that he chose to be a judge because of what he saw, what happened there for Mr. Aldenburn? It was wow. Anyway, there's a lot of backstory, and so when you see Mr. Aldenburn sharing a huge personal story that seems a bit outside of what's relevant for an argument, about his uncle serving in World War II and later taking his own life and everything, and then you see the judge respond, restating everything that he said, and then making his ruling and siding against him. Okay. I think there's a level of respect there that has always existed between these two. That's always existed. I don't think that's anything that would cause a mistrial. Not at all. There's nothing improper about anything they're doing. I don't know where the feed went, but we'll go here. During all this, my computer rebooted. This is why I love streaming on hardware and not on software. Had I been streaming through my laptop through like StreamYard, the stream would have gone down during the middle of that. But nope, I have a hardware that keeps me running. So yeah, we've got a lot of history there, and watching it play out here explains a little bit why the judge is doing that. And so I don't fault him for that. I think it's a sign of respect. I think he still made the right decision. And many times he's come down against against the defense when he's like, look, respectfully, I disagree. Take it up with the appellate court. I realize that was your job before over me, but that's where it belongs, because this is my job to make the ruling, and I'm making it, and I think I'm right. So yeah, crazy. Yes, Greeners, thank you very much for that. That's Carroll v. Carroll. There's the citation for the case that I just referenced about the family law with 16-year-old Hunter Carroll appearing in that one, filing a motion through his mom's attorney. All right. Let's see. Let's exit that one. Things are slowly coming back together. Let me see if I think we're still live. We are. Just kidding. Of course we're live. All right. we have a couple other things we need to talk about. Everyone's asking about the JC situation. This has been huge. This is the elephant in the room. Everyone wants to know how this is going to end up. And things are happening right now regarding that. But they're not happening in court. The judge mentioned it a little bit, and in his mentioning it, okay, he says, I'm already envisioning in my head, I'm putting together the words that we need that will have to be inserted in the jury instructions for when this goes to the jury. So that, to me, says he can see where we're headed. He can see the path this is going, and it's going to end up going to the jury, which is huge. Okay, so that's what his leaning towards. That's where he thinks we're at. Okay, now the judge still probably knows less about this IJ than any of us do. He knows nothing other than what we've heard in open court. He hasn't looked at the reports that we have, and we've gone through them. We've got 50 pages of reports with just stuff coming out our ears as far as what's happened with the hospital. I'm reading things where it says an unannounced full federal and complaint investigation. Unannounced. This is not self-reported. This is not, hey, we just wanted to say we just noticed something wasn't up to snuff. We're going to go ahead and tell the commission, hey, we noticed a problem within our hospital, and we want to let you know that we're trying to fix it. This was not self-reported. An unannounced full and federal and complaint investigation. This is in 2018, okay, and these are done every 3 years. So they cover a 3-year period. So what Mr. Whitney said, they have a 3-year look back. That means 2015, 2016, 2017, or 2016, 2017, 2018. I don't know how current the front end goes. It's probably too current, so it's going to be 2016, 17, and 18. But it says a full unannounced survey was conducted at Johns Hopkins All Children's Hospital on 1/7 of 2019 through 1/11 of 2019 for a review of all hospital conditions of participation. This is basically to see if you can still be credentialed as a hospital. You can still qualify to get the payments that you do from the government. The hospital was not in compliance with conditions of participation. Quality assurance, performance improvement, medical staff, infection control, the ongoing immediate jeopardy was identified beginning on 9/20 of 2018. So this is the first time the IJ found it. It was 9/20 of 2018 related to the governing body condition of participation. And to me, it looks like this is systemic. This is system wide. There are a couple of references. They have some problems in the cardiac place, and you can find that in the documents. You can find that, but yeah. All right. Who says they have no sound? It's just your end. I'm pushing a solid -8 decibels. I'm a little loud on my little meter. I guess it's not -8 decibels. 0 is the very top. Once you hit 0, you've pegged. You've redlined the system, and I'm -8 below that. Anyway, there's everything. There's reports. There's pages and pages. There are 10, 11 reports that have to do with this. Some of them are 50 pages long. Anyway, what's happening right now is the judge has ordered, and he did order, that the hospital turn over all these documents. We have some of them. We have the public ones. There are others that are not public. The initial report, the initial IJ finding is not public. The hospital has it. And the judge, according to what I have been able to ascertain, believes that he has asked them to turn it over. I believe that the wording was not precise enough to force the defense to hand it over. And so there's a chance that the defense does not hand over that original finding, that they can somehow comply with what the judge said by turning over other ancillary documents in this situation. Those other documents might have more favorable wording for the defense. They may have documents they turn over that the hospital itself has produced in response to this, which is like we release our annual report of how we're doing, and they sort of address this in lighter, more flowery language that sort of glosses over the jeopardy, immediate jeopardy issue. You can see that on their website if you go to that. They might produce those, but if the judge feels that they have not been truthful, if he looks at this and says, where's the initial, and it's not there, he can probably flip his lid, like we almost saw him do the other day, and say, I am ordering that right now the hospital turns over these documents. We'll wait, get on the phone, I'm ordering it, and get somebody here now. He has authority. He has subject matter jurisdiction to place an order like that. And the problem he's got, the problem defense has, is when the judge mentioned this morning that the problems associated with this issue, it's not just for the case. There are issues that Mr. Hunter is dancing around very carefully that could impact his career. I'm just saying, if there was proof, if they can prove, and it's a difficult thing to prove, if they can prove he had knowledge of this witness misleading the jury, sharing false information, saying that the hospital was wonderful and everything was coming up roses, and did not do it. As an officer of the court, he has a duty to correct that information. And that could be huge. That could be huge. Yeah, I mean, there's disbarred is an ultimate option. Now that there's a lot that has to be proved to make that happen, and I'm not saying that has occurred. I'm just saying the judge is aware of these issues. He's aware that this impacts. Yes, it's huge on the case. It's huge for appeals. I mean, this has appeal written all over it in bold red letters. Okay, it's not going to just stand on its own and be like, well, that was the judgment. It's going to be appealed 100%. Oh, man. The plaintiff also has all the documents we have. The plaintiff, to my knowledge, Crazy Cat Queen, does not have the original finding, the original IJ. Now, this is the one, if you remember, was it Mr. Anderson? No, not Mr. Anderson. It was the plaintiff witness from yesterday, the doctor specialist, the guy who drops all the names and has the wife with a Greek restaurant. When he testified that he had...
I need to get my computer
heard about it.
Unlocked here.
He had heard about this through a phone call, and that's how he knew that they had it.
Sorry.
It's a protected document. But
Mr.
it's supposed
Whitney
to be coming
is
out. Here we go.
Out there somewhere in a waiting room or something. Could you let him in, because some of this damage, the damage questions that we have, he's going to be more familiar than I am.
I will promote him to a panelist.
Welcome, Mr. Whitney. I see him on the
Not quite the
see him on
military
Zoom.
rank that I'm sure he's familiar with, but in Zoom lingo, that gives him
He's in a nice hotel room.
almost all access.
Hey, any promotion is good.
Mr. Whitney is in fact a commander in the Navy.
I'm aware. Doesn't he fly fighter jets or something like that?
He flies
Nothing that cool.
including helicopters.
Helicopters.
50,000 parts going different directions at the same time.
In any event, there's Mr. Whitney.
Sorry.
Okay. Now, let's go to the verdict form. Let me make a couple
Might be at
of
home.
general observations.
I thought he was in a hotel, but he might be at home.
The following observations are going to come as a surprise to Mr. Altenburn, since he has had a previous case with me and he knows kind of how I like to format things. But I'm going to be very specific after each question, what the jury needs to do, go to number whatever.
The directions.
Agreed.
And it's going to be very clear. It's going to add length to the verdict form, but the ultimate goal and hope is that there will be zero room for misunderstanding. Now, that's the goal. If when you see what I do, if you think it interjects any hint of confusion as to what the jury needs to do, let me know and flag it for me.
Yes, sir.
Okay. So I will, in the version that I hopefully will get to you Friday afternoon, that will be included. Now, I will also attempt to mirror the language that we use in the jury instructions on like medical care, nursing care, and all that If I've pulled something out for a specific claim, I will try also to pull that exact same language out from the verdict forms, such that the two should mirror each other. Again, if I fall flat on that, highlight that for me. I do like the change back to kind of what I was thinking, that we would do liability for punitive damages right after false imprisonment, and then a separate punitive damage liability after battery.
It didn't work the other way when I.
Yeah, I think it has to be this way. Now, I want to ask very specifically as to the following. We'll use false imprisonment as an example. There are 3 different instances of false imprisonment that plaintiff have claimed. The verdict form as it was presented by the parties would allow, if 1, 2, or all 3 are checked, yes, would allow for a singular damage line instead of a damage line for each specific separate battery. Is that what both sides are specifically requesting?
Yes, I've had discussions with my client about whether we needed to itemize everything and make the verdict form even longer for the jury, and the decision was that for false imprisonment, we would just have the economic, non-economic breakdown and not more than that. So that, and I.
Economic, non-economic, and then under 768, the in the past and to be incurred in the future.
Well, yeah.
What's required.
Well,
the economic, and then you have non-economics, and the non-economics are divided further into.
Okay, the first question is
the compensatory damages are being aggregated for all issues of false imprisonment, as well as separately for battery. I just want to make sure advertently that each side is requesting that, because what I don't want to have happen is I don't want either side to say Judge Carroll did not have specific line items and there's no way in the world I could determine that, let's say the jury picks on false imprisonment 2 of them, and then the appellate court reverses as to one but leaves the other. I don't want the damage award coming back at me because of the lack of apportionment by claim. So I'm fine if both sides expressly say that that is what they want, and they're going to lose any ability to say that Judge Carroll did not give me a specific line item for that specific false imprisonment. And so I'm fine doing it this way, but I just need both sides to tell me that that is what they want.
Go ahead.
I'm thinking, because what you're saying is that if, for example, the second district held that there was no false imprisonment between October 18 and October 20th because of the fact that she was still in a room just like her other room and probably didn't appreciate that she was being restrained at all, then if they've checked that box.
Let's say if they check the box, yes, there was a false imprisonment between October 7th and 13th, right. But no, there wasn't a false imprisonment for October 18th and 20th. Yes, there was a false imprisonment on January 6th. Let's say the second DCA cuts the January 6th finding but leaves the October 7th through 13th. Mm-hmm. The verdict form as read would not have a damage, so effectively it wouldn't matter if the appellate court reversed as to one, so long as there was one remaining.
And I think you're right, and as a result of that, I think I need to have separate damages for A, B, and C. I think it has to be laid out separately for each one.
Okay.
We object. We object. We think that, again, we're getting into this area of overlap, and we're willing to take the risk on this, that the damages overlap sufficiently in a category now of false imprisonment such that even if one out of them is eliminated, or even two of them are eliminated, it's not really going to affect the overall amount of those.
I'm going to separate and put additional damage lines because I think it's important to give the jury the ability to award damages for the specific conduct that it finds to be a battery, assuming that they were to find it. We'll definitely include some sort of non-duplication language. And that way it also gives the appellate court the ability to know what the jury was thinking. If the jury comes back with any sort of yes finding. I mean, if they come back with a no finding, it's a academic issue at that point.
Well, note our very.
I hear that you want less damage lines on the verdict form.
I just don't want. I think it's going to breed confusion. I think it's going to breed questions, and I really don't think, based on the history of Florida law, it's going to make that much difference because we always had in our verdict forms a number of different counts, and as long as there are the damages here, if there any one of them that supports that, there's a basis.
Well, I'm more of a fan of interrogatory answers, and more information in my world is better, and whether that helps or hurts, it kind of is immaterial to me. I want information. We ask the jury to make findings, and that's what I'm going to have them do. They'll earn their pizza or sandwiches that they get for their lunches and dinners.
And as a result of that, I'm going to need the same thing in battery for A and B.
Yes, sir. We will recast it such that.
Are we talking about this language?
No, he has rule.
Sorry, on battery of Maya Kowalski, is that already determined? It's going to be and the other two employees? 2A?
Plenty of evidence.
Well, I was only talking about conceptually what I was going to be doing to the verdict form.
Right.
I haven't gone to any specific language.
Okay.
In the jury instructions.
Was from a structural standpoint.
We have some non-duplication language down below.
I saw
Is this
that.
new,
and
Green-eyed? Is it commenting right now?
I will. You'll see what I do. And again, I'm hoping to get this out to you all on Friday afternoon. That would be my hope. Now, let's go if there's specific language that someone needs to address.
Ms. Call just pointed out something to me that would impact the language, the same language in the jury instructions, by the way, but she has a good point. The two other employees have been referred to in front of the jury repeatedly as the two bedside nurses.
That's probably okay.
It would be less confusing to the jury if we called them bedside nurses rather than other employees.
The only testimony I'm aware of, Judge, on these photographs is that it was Kathy Beatty and a bedside nurse in the morning and Kathy Beatty and a bedside nurse when she came back. So I think the jury might be confused as to who you're referencing if it says Kathy Beatty and the two other employees. I don't know that they're going to connect that, and I think if we change that to bedside nurses, it would be clearer. It's my suggestion.
Okay, well,
We don't agree. There's evidence from Maya Kowalski about being dropped by.
This is
No. That's not in this case.
We're talking about the battery.
We're talking about the photographs.
The photo session or sessions.
Yes.
Her dropping in that room is not bad.
Mr. Anderson, go to page 4, question 2A. That's where I think Ms. Crowell's is.
Yeah, I just think that could, they might, I think they're going to be confused by that. There's only been bedside nurses discussed as being in the room.
I am conceptually fine calling them bedside nurse, but here's a slight wrinkle.
Okay.
Maya Kowalski, again, has taken the position that there were not 2 photo sessions.
No, I
and that there was only one.
That's true.
But I guess she also talked about there was one photo session, but there were 2 different hands.
Yeah. But the second hand, she says, is Kathy Beatty.
Right.
So maybe it could be Catherine Beatty.
And the bedside nurse.
And any other bedside nurse.
And any bedside nurse. Or
any bedside nurse, because we say it's 2.
She says
it's 1.
Yeah. Sorry, I didn't mean to talk over. Yeah, so maybe did Kathy Beatty and any bedside nurse commit a battery on January 6th? That makes sense to me, Judge. It takes out the numerical issue.
I like that.
We object. We're micromanaging the facts of this.
My job is to make a very clear instruction and verdict form. We're talking about batteries. The only evidence for the photo session, even from your own client, was Miss Beatty and the nurse. So I don't see why it's a problem to refer to it as a bedside nurse. And I like how Miss Crowell's couched it so it also avoids the 1 versus 2 photo session issue.
It's the employee work they took out. That's the problem.
So I'll recast for that.
Judge, just in response to Mr. Anderson. Oh, I'm sorry. I retract. Never mind.
If you see something on Facebook with a comment, send it to me. From what I've heard, it sounds like it's okay if he just says I'm not going on vacation.
With language.
I'd love to see it. Send it to the burner phone.
I think there's some questions, Your Honor, that Mr. Alton-Burnett raised, like on page 2, on different elements of damages within the economic and non-economic. And I think Mr. Whitney might be able to speak to that because I'm not as familiar with the evidence.
Okay, well, when we talk about the aggravation and that language, I was going to mirror it to what the jury instructions were going to say. Are there other issues that I need to address?
We took out the word decision. I guess the simplest way would be if there isn't anything, the jury's just not going to award for it. I mean, they know what they've heard.
Judge, I'm sorry. We lost where you are.
Page 2.
It should line up with whatever is left in the jury instruction. And when you change that, if you could look at this, it should line up with that.
That's what I was saying right at the beginning is I'm going to attempt to mirror what is in the jury instructions over to the verdict form, and that would be my intent. If I fall flat on that, I need you to highlight that for me, but my intent is if I make the change over in the jury instruction, it should flow to the verdict form and mirror in the verdict form what is in the jury instruction.
I would note, by the way, on page 4, the blue and the red are the kind of 2 initial non-duplication languages that were being used. And there's something like that in all of the affected counts.
I'm not sure it did get repeated.
Okay. I will. You will see what I do if we need to take out some non-duplication language or add in additional non-duplication language. You will get that opportunity. So,
and Your Honor, what I was trying to do is figure out, and I really didn't succeed at this. Figure out the red line is what we would propose, and to put it someplace near the beginning, maybe the first time, and maybe considering a second round of damages, so it doesn't get repeated all the way through there. That seems going to just make it longer.
Mr. Whitney's on Zoom.
So you want the red, the defense wants the blue?
I think that's correct.
Are there other language issues we need to address?
Yes.
Ms. Carlos.
On the battery, inner battery?
Wherever. Let's just...
2B. When it says, did Catherine Beatty commit one or other batteries on Maya Kowalski at other times described in the testimony, it makes it a given that it happened.
Yeah.
I mean, that's saying, as described, did she do it? And so I think if there's going to be a question, I didn't think she was sued for any other battery other than the putting on the lap and the photo. So this makes it sound like she did it. So I think that at other times described in the testimony is endorsing that happened.
I was struggling with what to put there because this is the one that actually you didn't direct a verdict on for punitive damages. These are things that happened over the 100 days where she says she was touched and didn't like it in her room.
I think the only one was, I thought the only one seriously was putting on her lap and hugging her.
No, it's alleged as two different things. When we specified the points of battery, that it was alleged out to three things: the EEG room, which is gone, the things that were in the chapel or somewhere else that.
All right. Okay, I hear you. So, but can it just be did she commit? I don't know, but
I'll look at it. I hear the concern.
Okay. Okay. All right.
Because I mean, it was the allegations are this took place in the chapel. I'm really flexible on that. I didn't know what to put down there.
If I could comment briefly, if the court would, when considering it, look to paragraph 79. We described unwanted hugging, patting, stroking, slapping, caressing, and kissing. Some of those things occurred in a room. Some of those things occurred in and around the vicinity of the chapel.
Yeah, I'm not looking to limit it to the chapel or her room. I just didn't like the as other times described.
I'll look at paragraph 79, and perhaps if that is a complete roster of the allegations, then we'll substitute that roster of allegations. But what's next? Are there other language issues?
I think on toward page 6, Your Honor, the med mal, it's the next one I have. Under C, I was concerned about a little confusion there. Health provider other than Sally Smith, for whom Johns Hopkins is legally responsible, and you see the comments out on the side. It admits it's responsible for all others. So I don't think we need the for whom it is legally responsible in there.
I'm not following what you're asking me, Mr. Elliott.
6C.
No, I'm there, but what are you trying to get me to say?
I think delete the language beginning that says for whom Johns Hopkins All Children's Hospital is legally responsible. Because that's redundant. Because
it needs to be.
I understand the response. I'm sorry.
My apologies.
I thought they were admitting they were responsible for everybody, for all the healthcare providers other than Sally Smith.
Well, it needs to be not Dr. Hannah or Kirkpatrick. I mean, it needs to be tied to John Children's Hospital.
Well, that's the only claim, right?
Well, the testimony's been, though, about other doctors doing other things.
But they didn't see her in the hospital, did they?
Okay. They didn't. I just want to make sure the jury's interpreting the question to be during the hospitalization. And you know.
Maybe that's the way to say it then.
Well, what about one or more healthcare providers employed by Johns Hopkins All Children's Hospital? Because all these other people that we're legally responsible for are actual employees.
Well, but then figure that out. Yeah. Or one or more healthcare providers employed by Johns Hopkins, other than Dr. Sally Smith, which gives the impression that Dr. Sally Smith was employed.
Yeah, we don't want that.
Yeah.
How about just say during the stay? I go back to what Ms. Krause was mentioning earlier.
Well, I can't give an impression that Sally Smith was employed by Johns Hopkins, especially since I'm telling the jury that she wasn't. That the only question is whether she's an apparent agent.
Right.
Right. I think what Ms. Sproles was saying in C, if we took out the for whom Johns Hopkins is responsible, but put in there someplace during the stay at Johns Hopkins All Children's Hospital were one or more of the healthcare providers other than Dr. Sally Smith negligent.
Okay, then how about, from a conceptual standpoint, if the jury checks the box that Sally Smith was not the apparent agent, then there would be like an instruction, a sentence on the verdict form that says, for this next question, you may not consider any act by Dr. Sally Smith. And then do was there one or more healthcare providers were there one or more healthcare providers negligent in the medical care of Maya Kowalski, something like that. So if the jury has just checked no, that Sally Smith is not the apparent agent, the very next question that they would have to answer would be inclusive of some sort of instruction saying they can't consider Dr. Smith for it at all.
I think that's what happens with the way, if they work through it the way it is now, the way Mr. Altenburg drafted it. I think the only confusion is in paragraph C.
I mean, if Your Honor would like to try something so we can look at that I understand what you're going at. And it occurs to me while we're discussing this, I don't know how Mr. Anderson plans to argue this, but we might need to say, other than Sally Smith and Catherine Beatty, if there's going to be any suggestion that she was a health care provider, because she's not.
I think we might need an instruction that Kathy Beatty is not a health care provider.
I think you have flagged the issue for me, and you'll see what I do. And then you can propose alternative language if you feel if I fall flat. Anything else on language?
I was unclear on page 7, the blue.
Oh, well, maybe that was me being tongue-in-cheek.
Probably not appreciated right now. What's that?
So I think I can delete the...
Yeah, your rulings are such that you can delete that.
And I think that then with the instructions, if you down on the next thing under 4, you harmonize that with the instructions.
That's probably a better word than mirror, so harmonize. I will attempt to harmonize. I would harmonize number 5. Are there other language concerns?
Page 10 or something?
That's just conforming to the damages, I think, right? But page 11 does have...
I note that in 6 on fraudulent... This says fraudulent misrepresentation. It should be fraudulent billing. Well, it is a fraudulent misrepresentation count, but Mr. Elliott never put a damage line in that one. And I did not either.
Okay.
Should we change it to billing? That's the only thing the jury's heard
They've
about.
heard billing.
It's gonna be billing.
Yeah.
Okay.
But, and then I'm not quite sure how you're going to do the damages on that.
We'll see on Friday. See if we can get it finished.
I think on page 11, that'll need to be reworked in light of the rulings on the instruction.
Right.
But Your Honor, I think one thing we agreed on, we talked about yesterday, is that there would be one line for uncontrollable and one line for substantial factor. One question for each of those.
Yeah, so an interrogatory option, yes or no.
Yeah, and it's set up that way now. It just needs to be reworked or harmonized.
Anything else?
Not sure.
I don't think so.
Just if the lines for the damages are not big enough to put a letter in, let alone...
I'll make them smaller.
We agree.
This was a rough formatting.
Yeah. There might be humor involved in that.
Judge,
I can negotiate the length here.
Judge,
But I'm not going to make it landscaped to make it an 8-inch line either.
It only needs to be half the page, Judge. It will be fine.
Judge, outside of this issue, there's one exhibit issue that needs to be resolved, and I see Mr. Whitney's here.
Is there anything else on verdict form before I pivot to something else?
The only thing I would kind of highlight for you is that from intentional infliction survival, your instruction on where to go next, I've done a bit on that, but it's a little complicated because if they answer no, they jump all the way to Maya's intentional infliction, and if they answer yes, then they go to the next one. So that just needs to be done. I think I got it, but you may think it could be done better.
Wait a minute now, because they should be answering both survival and wrongful death.
Absolutely.
No. If they answer no to survival, they don't get to wrongful death. That's what our instructions tell them.
Oh, you're talking about the top of 7.
Right. If there's not enough emotional stress to cause survival damages, then there certainly is not enough to cause wrongful death. So you jump on those. Now, at the end, if you get both, you're going to have to elect. I think I know which one to elect.
Elect afterwards. Yes. Okay. Sorry.
Okay.
Well,
I knew what he was talking about.
I'd rather have them both answered.
Anything?
No, there's nothing more from our side.
Tom?
And to confirm, you're also going to read and give them a physical copy of the dependency order instruction that was done before. We weren't asking for any changes in it.
That was my intent.
Okay.
Okay, so is that going to be read again, the 10-page thing?
Yeah.
I thought that was just going to be given to them.
Well, I guess theoretically I could just give it to them.
I had told you before that and I maybe should defer to trial counsel on this, but it's going to take a long time to read these things. They've heard it once, they know what it is, so as long as you tell them that it's there, and if they need to read it again, it's there, I'm not going to object.
It's a 10-minute read, so it's not the end of the world, but it does take some time.
We had a couple of additions to the dependency orders, Your Honor.
Well, send those to me. Specific language that you were asking or to be deleting. I think I had circulated the Word version of what I actually read. I believe I did.
You did. And if they have additions, I haven't seen anything about that to this point.
It's going to be so much easier if you send like a legislative style, add this language and strike out this language to the actual physical Word document. It's so much easier to see what it is that you are asking for, or whatever the issue is. So please do that, and then let's talk for a moment as far as timing, and then we'll pivot to some of these other issues. My hope is that I will be able to get to the lawyers sometime late afternoon on Friday. My goal is to get my draft of the instructions and the verdict form to you. It all depends on how long that meeting goes and whether I have Wi-Fi in Wesley Chapel or wherever. If I have to pull into a Cracker Barrel or something to grab someone's Wi-Fi, I'll make it work somehow. It's just I don't know when I will be able to do that. But my goal is to get it sometime Friday afternoon. Assuming I can get it to you Friday afternoon, would you be able to get to me any suggested changes, additions, alterations by let's say 3 o'clock on Saturday?
I have no problem doing that. I would want to confer with Ms. Crawls if you're going to be available. Yeah, that should work fine.
And then I would try to get back to you any sort of further comments to your suggestions or rulings, or by, I would say, hopefully around noon on Sunday.
Okay.
And then if there was anything further, that you would get it to me by, let's say, 8 p.m. on Sunday night, so that I'll have those last minute points, so that when we walk in on Monday morning, they should be pretty much finished, with maybe possible, a nit here and a nit there.
My only concern at all is that I know Mr. Shapiro on our side and Mr. Anderson on the other side are preparing closing arguments and displays for the jury and whatnot. I don't know how much, if we do too many changes on this in this time period, it may impact people's adjustments to their closing arguments.
My hope is
I'm betting by 3 p.m. on Saturday we have something close. That's what
I think that, and then on Sunday, when I forward something at noon, we're probably going to be relatively close.
Yeah, if there were substantial changes at 8 o'clock on Sunday evening, I have a feeling I'd hear from Mr. Shapiro about that.
And by giving you the opportunity to file something at 8 o'clock, that doesn't mean you need to. It's just it's just if there was something else, so that I'm not caught flat-footed Monday morning, because Monday morning is going to be tough enough as it is.
Yep.
Okay, so any questions on the timing before we pivot? Okay, so let's pivot. Ms. Croyles, you wanted to talk about something?
Mr. Whitney, you're there. It's the one exhibit. We have a couple minor exhibit things we're working through, but this one, the plaintiff has admitted, and they want to redact some things that we disagree with significantly. I don't know. Can you put up? Are you set up to put up an exhibit number? 2408.
if I could jump in for a minute, if it's all right, I think I'm done. Your Honor, if I'd be excused, I've got to get to that seminar. Thank you. Thank you for your time.
Do you have the highlighted copy from Mr. Whitney that you could show what he wants to redact?
I'm not sure what page on 2408 are we referring to.
Okay, so I can just describe it, or Mr. Whitney can. But I received if you can put it up. I received an email from plaintiff's counsel highlighting what they want to redact on this, and we disagree because we think they're all admissions with respect to things. So,
what page on 2408?
Oh, I'm sorry, 1738 and 1739. So this is in evidence, Judge, and then you may recall plaintiff said, oh, wait a minute, we want to redact some things after it's already been admitted. They want to redact starting from on the first paragraph, a woman from CPS showed up to the end of that paragraph. I don't know if you want to just take them one at a time. But I do think it's important you read it in context.
Doesn't that go to her knowledge as a parent agent?
Yes, exactly.
So that's going to stay in.
The next one they want to redact is on page 1739, the paragraph, the first beginning paragraph, Tuesday M 1011, that paragraph. They want to redact. Obviously, at that time, Dr. Vose or one of her associates already notified CPS but didn't tell us anything about it, so we were blindsided again. I'm less concerned about that.
Is this, just so is this, so this is on the 11th, this isn't on the 13th?
Correct.
While the judge is reading that, someone asked for my gear list. I added it to the very bottom of the video description.
One that starts with obviously at that time, Dr. Vose.
And I'm going to post a link in chat for
leave in the 10 people in the room and police officers in the hallway?
They want to leave that in, yes.
I'm going to post in chat a link to a TikTok video that compares the two voices that we're talking about.
Mr. Whitney, what's your thought on that?
Yeah, the overarching goal of these redactions is to keep out Chapter 39 issues. So this is indicating a report. The jury is aware there's a report. The court's made a legal determination about there being a reasonable suspicion. So the reporting of Dr. Vose is not for the jury. And you all are moving quickly. I'd like to go back to the first paragraph. We don't have to do it right now, but at some point.
Well, I'll give you an opportunity to say what you want to say, but that first paragraph goes to Beata Kowalski's knowledge relative to Dr. Sally Smith and the apparent agency issue. So I'll give you an opportunity in a moment, but
sure.
I'm pretty confident on that one. Now, on this Tuesday AM paragraph, I don't see, Ms. Crowell's, what that sentence that Mr. Whitney is trying to have redact, what issue that goes to or defense that goes to. It just seems an unnecessary reference to the Chapter 39 process.
Well, I think the context is important for her comment about there were police officers in the hall and security person. It's not, they're not saying the police officers are there because they want to leave against AMA. They're saying they believe the police officers are there because it's been reported to CPS. So we're fine if we want to take out the comment about there were two police officers in the hallway and security person, because she then says, obviously, they notified CPS. It wasn't.
But the problem is, I've already instructing the jury that it wasn't until the 13th. So I don't see how that sentence gets you anything.
Okay.
And so I would agree that that sentence comments on a Chapter 39 issue. So I am fine excising out the obviously at that time sentence.
All right. The next
Mr. Whitney, hold on, Mr. Whitney, say what you want to say about that page 1 comment.
Yes, Your Honor. Thank you. Page 1, it says a woman, says women, but grammatical error. A woman from CPS showed up here. It does not identify that woman as Sally Smith. If you look at the second page, it says the same woman from CPS came back. I'm sorry, I'm kind of jumping around here, for Your Honor. I don't think it's clear on the first page that the woman being referred there is Dr. Sally Smith. So that sentence, a woman from CPS showed up here, I think it's unclear. And the next sentence, we were totally blindsided. Understanding the court's view on that piece as to apparent agency, I have a bigger issue with the next sentence, which is we questioned what this is all about, and we were informed that this is a standard procedure in ICU when a child is on so many different medications. And then it goes on to discuss the laws in Florida being different than Illinois.
Well, so my understanding was you were only, Ms. Quarles was only talking about that one sentence.
Oh, no, I'm sorry, Judge. No. They wanted to redact, I thought I said the entire sentence after that, a paragraph after that.
I just thought it was that one sentence.
No, I'm sorry. They wanted to redact, let me make sure it's clear on the record. The plaintiffs are requesting to redact the remainder of the paragraph, beginning with a woman from CPS showed through and her meds.
Well, that's a different.
Okay. Okay.
Okay, so where does, when you say this paragraph ending, tell me, Mr. Whitney, where your paragraph, what you claim the paragraph, where it ends.
Yes, Your Honor. We would request that it be redacted from we questioned what this is all about all the way through. There were a lot of questions regarding Maya's RSD CRPS diagnosis and her meds. We believe the entirety of that goes to, first, a legal conclusion, secondly, Chapter 39, and invades the court's ruling about there being a reasonable suspicion, and the jury doesn't need to consider that. And then the questions regarding Maya's RSD CRPS diagnosis and her meds goes straight to, if it's believed that this woman was Sally Smith, to her investigation and report, which have been kept out at all other times.
I continue to believe that the sentence, a woman from CPS showed up with 2 police officers to investigate what's going on, needs to stay in because it does speak to the apparent agency issue. But as far as the rest, Ms. Crows, do you want to say anything?
I do. I think I understand maybe that we questioned this thing, but the sentence anyway, CPS questioned Maya independently, then Jack and me, needs to stay in because that's, again, indicating that they knew the woman was from CPS. And then there were a lot of questions about her RSD, CPS diagnosis and meds. That's Sally Smith. So if you want to take out the middle of that, we questioned through different in Florida. I don't care. But anyway, she questioned Maya independently, then Jack and me is clearly referencing Sally Smith.
I can agree that anyways she questioned goes to apparent agency. The next sentence, however, there were a lot of questions, goes straight into Chapter 39, her investigation, her opinions.
I will agree to redact the paragraph starting, we question what is this all about, through the remainder of that paragraph, which is laws different here in Florida, ? So that comes out. The sentence, anyway, she, CPS, question Maya independently, then Jack and me stays in. The next sentence is out.
Okay. All right. I think I have a hard copy of this. I should have been making notes.
I've got notes. I'll recirculate.
Okay. Thank you. Thank you, Mr. Whitney.
Okay, anything else on page 1?
No, not on page 1. Not on page 1.
No, Your Honor.
Okay, so I've already ruled about something on page 2.
You did. You ruled on the paragraph that begins Tuesday a.m. You have deleted or redacted. Obviously, at that time, Dr. Vose or one of her associates. Yes. That sentence.
What else on this one? that's in dispute?
The next paragraph that starts Tuesday, 10/11, late afternoon. Mr. Whitney would like that sentence.
Well, I can modify based on the rulings that are being made here.
Okay. Well, go ahead, Mr. Whitney.
I would agree that Tuesday, 10/11, late afternoon, the same woman from CPS came back because of second, I don't know what CO is, from hospital staff. I think it should end there because the next clause, she received, I don't know, CO, that we wanted to take Maya AMA and to take her home. That's a lie. That goes to the Chapter 39 reporting.
I think that goes to the false imprisonment claim.
Yes, exactly, Your Honor.
So that sentence has to remain in, Mr. Whitney.
All right, understood. The next one, Your Honor, is if you move down halfway down that paragraph, it begins Tuesday, 10/11 evening. I have another supersized visit from Sally Smith. All right, I need to read this to myself for a moment to decide if consistent with the court's rulings, it's going to remain. I think that first sentence, supersized visit through to investigate this child abuse neglect case, would stay consistent with the court's rulings here. But then I think the 1.5 hours and the investigation and the questions she was asking and how these administered, all of these things are straight into Chapter 39 and Sally Smith's investigation report, which has been previously excluded. So I would suggest that the balance of this section from I spent 1.5 hours down to the end where it says when she first spoke with me be redacted.
My only comment on that, Judge, is I believe Dr. Smith testified that she spent, I could have this wrong, but I thought she testified that she spent 1.5 hours with her. So it'd be clear that this would be the same visit that Dr. Smith talked about. So we could just say, I spent 1.5 hours with her and end it there if the court is concerned about the rest being a description of her investigation.
I'm not.
She's fine reading off the phone. There's no problem with that.
Sentence, I spent 1.5 hours. It also reinforces the question of apparent agency. So I would excise in this paragraph, starting with she, Smith, asked a lot of questions.
And to where, Judge?
I think it goes all the way to when she first spoke with me.
Well, if we're arguing that this is all relevant to apparent agency and her role as a treater, then I'd like to keep the last sentence. FYI, she didn't know anything about RSD CRPS when she first spoke with me.
Well, that goes to the investigation, Judge. If we're going to leave that in, we got.
Well, I mean, to be fair, it is a statement about her knowledge base, and there is a question of apparent agency.
Okay.
So I would leave in the FYI. So I would redact starting with she, Smith, asked a lot of questions all the way through with her presence and will be questioning you. Anything else on this exhibit?
And then the last one, Your Honor, and thank you for your patience, is the very next paragraph. Today went through Wednesday. Someone from CPS visited Kyle. Then CPS showed up unannounced at my home. I think those are Chapter 39 issues.
I don't think you're. Yeah, that can come out.
That's it, Your Honor.
Okay, Nick, you'll send that to me shortly so I have it in my head.
Well, time out.
Sorry.
What about the next 4 or 5 lines? I think the ICU person who reported us is doing this.
Oh, yeah, that needs to come out, Judge. Thank you.
Well, no, I disagree because the jury is aware of the reporting.
But that goes to directly against the judge's ruling that it was done in good faith or reasonable cause.
And
it's not an issue for the jury.
All right, go ahead, sir.
Go ahead, Mr. Whitney.
I understand if that's and it seems like the court's leaning that way, then I think it should pick back up at, I cannot tell you how devastating this is to us, Dr. Hannah.
that goes.
I'm okay with that, but we need to take out the sentence starting with, I think the ICU person,
Yes.
all the way through Munchausen by proxy.
I've got it.
Okay, and so, Madam Clerk, how do you want this presented? You want this as an A, or do you want it as a separate trial exhibit number?
Is that replacing what we already have admitted?
Yes.
Okay.
But we need the unredacted version so that it can travel with the appellate record. So
Okay.
do you just want to just make this 1738 and 1739 as marked for identification and just have an A?
Yes, sir.
So would it be 2408A, 1739 and 1738 and 1739? The A goes after 2408? Okay.
Does it go after the 2408 or does it go after the 1738?
After the 1738.
Okay, so
1738A and 1739A.
Okay.
Will be admitted, and the A version will be as redacted that we just, and then the regular 1738 and 1739 will just be ID'd but not admitted.
Thank you, Your Honor.
Okay. Mr. Whitney, can I just ask Mr. Whitney a question real quick,
Sure.
Judge? I know you've got a lot of things doing, but can you get that to me fairly soon? Because I want to look at it while I didn't take good notes. Well, it's fresh in my head.
Sure. We'll have it to you within an hour.
That'd be awesome. Thank you.
Okay, we just made a command for Jules. So it should work
What's the
now.
next thing, Ms. Quarles?
I don't think
Save
there's.
our mods some time.
I can be corrected, but I think otherwise the exhibits are in good shape. You're missing a couple things, right?
Yeah, I believe as of today's date, we're missing 2 exhibits.
That we're going to get to you by Monday.
Right, and then we're missing a
Oh.
couple from the plaintiff.
Yeah.
I don't know what else is going to come in Monday morning, maybe.
And also, do we have the Excel?
Yeah, I didn't give her the actual Excel till it's finalized. I just gave her printouts, not the actual thing. But
Can I get a?
Oh yeah, I have an extra copy, Judge.
Thank you.
But my other question is, I haven't heard any feedback on the language, so I'm assuming we're fine with the description of the exhibits. I don't want to be told Monday morning that we need to change the description of the exhibits.
I looked at it and initially it looks fine.
Okay.
I want to, if we have some additional questions on it, we'll give you a call, let you know in the next couple hours.
Yeah, as long as I get it by sometime Friday, so I get some assistance in correcting it.
And I do want to get out of here and start back to try to figure out how I could possibly put all of this into a closing, but not to say it'll be.
You have way too much time. You've got 3.5 days for just 2 hours.
I don't even figure out the jury instructions in 3.5 days.
I just remember the old days when we'd go from last witness to closing based on sticky notes I made.
Exactly. Judge, I had.
Well,
go ahead.
Was there anything else, Ms. Quarles?
No, I don't think so, Judge. I'm going to hand you this copy. I will note.
It's a copy, I know.
It's a copy. I mean,
Did you fill out the question 3325?
oh, yeah. I was going to check with my co-counsel. I didn't think 3325 had been admitted, but they say it has. I was just going to check with my co-counsel first. I may be totally off base on that. And we know this column needs to be made a little wider because it cut off some numbers. Okay.
I just needed to drop this.
You can always wrap the text for
it just needs to be made slightly wider, Judge.
But I'm talking about for the column to the right, the description, you can wrap the text so that if necessary, it can go to 2 lines.
Yeah, Allison's got it. She's wrapping. So I'm just trying to find that extra copy.
I feel like I have shown incredible restraint about not taking over the Excel spreadsheet.
I've been impressed with the restraint.
I don't have it.
I don't have it.
So I think Ms. Crowell's is finished with her stuff. Mr. Anderson.
All I wanted to do, Judge, the reason I've been hanging around is I wanted to deliver to the court and perhaps mark for identification a letter, January 31st, 2019, to Kevin Sowers, interim CEO, Johns Hopkins All Children's Hospital, that deals with the 2018 report and the results of it. And we are hopeful, although we haven't received it in time, if I may approach and give it to the court.
Well, I don't want to get into that, Judge, without.
If there's something you want me to read ahead of time, just give it to me. But file it separately with the clerk because I don't have time to have the clerk mark it and me get a copy of it because I need to get out of here.
Yeah.
So whatever you're giving me, I'm not putting in the court file. You're going to have to separately file with the clerk what you're giving me.
I will.
Now, has the defense seen what you're giving me?
Yes, I gave him a copy.
They don't like it.
Judge, I don't have an extra copy right now because I wrote on this one. I need my notes.
Okay, well, Natalie,
I can email you one.
Natalie's just going to make a copy of the Excel spreadsheet and she'll get it to me in a couple moments.
Yeah, I gave 2 up there, Judge. Okay.
Your Honor. Mr. Whitney, you're next.
And I got a bug out, so
Mr. Anderson's like,
you might want to hang for just another moment. Mr. Whitney.
Yes, Your Honor. If I could just comment on what Mr. Anderson just delivered to you. I won't go into detail. My question is, at this point, we have been delivered some documents regarding this Joint Commission issue.
They didn't do them all.
We have not been provided all of the documents that would exist, including the critical September 2018 immediate jeopardy report, audit, finding, however you want to classify that. So the question to the court is, recognizing it's Thursday at 11 a.m., how would the court like us to address this issue if we believe that there are insufficient documents being provided?
I was going to read what's been provided. Was the CMS notification 13119, the CMS survey 11119, the final accreditation report 81418 to 81718, get some done recommendations 62619, and the CMS revisit survey 22119 final.
That's BS.
I didn't hear the self-report in there. I mean, here is, and I want to be very clear about this.
Okay.
Go, Judge.
I am interpreting my instruction to turn over stuff very broadly.
Okay.
Very, very broadly.
Okay.
If there is a scintilla of odor, it needs to be turned over.
Okay.
And when I say scintilla of odor, anything having to do with the run-up to this report, all self-reports, any prior surveys by the Joint Commission / CMS, because I heard that Mr. Hunter say yesterday, well, there was a prior triannual survey that we passed with flying colors.
You want that? How far back do you want to go, Judge?
Well, let me ask this, and maybe you don't know this.
I might not.
Did anyone lose their job over this issue? Like, is this when the hospital president
my understanding
no longer
is
became hospital president?
Because of the heart issue that there was some, yes. I vaguely understand. Keep that with a grain of salt. I vaguely understand that as a result of the heart issue, there was a cleaning of house, so to speak.
Well, yesterday, Mr. Whitney said that the documents say that it was not confined to the Heart Institute and that it was systemic. Now, obviously, I'm not in a fact-finding position at this moment, but yeah. I need to at least assume the possibility that the reports are going to show more systemic than just heart-related. I mean, that's, I think, what the plaintiffs are telling me that the media accounts are.
I understand that's the allegation, Judge.
Okay, so knowing that I'm not making a finding of fact, but it sounds like there's an allegation, and perhaps the media also have made statements that it's not just the heart. I don't know.
Just saying.
This thing just kind of got dropped on me yesterday.
And all of these events are taking place after the events in this lawsuit.
Well,
right?
I'm about ready to get there.
Okay.
Mr. Whitney's
because it does sound like
and he can't
the
talk.
chief executive lost his or her job over this.
I believe that's accurate.
And so when did this chief executive start being the chief executive? Is this when...
Start being the chief executive?
Yeah. Is this when Johns Hopkins took over All Children's Hospital?
I don't know the answers to these, but I'll take the notes.
Because if we're talking about something that is systemic, something that becomes pervasive and systemic doesn't happen just overnight.
She's getting texts.
It's a culture that is created. And so is it when this president came in? Is it when Johns Hopkins took over the All Children's Hospital? Is that when the systemic problem started?
Judge, my understanding is that I forget the acronym of the organization that
Joint Commission.
Thank you, Joint Commission. That the Joint Commission report. I mean, they're looking for the documents, but that the Joint Commission report that was done in 2018 that they passed, and it was after that the hospital self-reported the issues with the heart stuff.
Well, let me ask you this. Was there media accounts that predated the hospital's self-report?
I don't know the answer to that.
Meaning, in other words, did the media bring this to the attention and then the hospital self-reported?
I don't know the answer to that.
But in my mind, if this is an issue of systemic hospital problems, and again, I don't know, I haven't seen any of the
Whitney
reports.
needs to do jumping jacks
and
right
all
now.
I'm going on is what I'm hearing in court. But if there is a systemic problem, if this president lost his or her job because of this issue, I kind of want to know when that president became the president. Because if we're talking about a creating of a culture, the inquiry, does the creation, or does it start with that president?
This is so broad.
I don't know.
Well, I don't know, Judge. I think that this is sort of going off the rails a little bit. I mean, the issue in this court for this jury is about whether or not, as I understand it, when the testimony was given that this hospital passed I'm sorry, the name keeps escaping me. The
Joint Commission.
Thank you. Oh, my God, I'll write it down. When this hospital, when there was testimony that they were accredited by the Joint Commission. And then there was an issue raised by the plaintiff, well, that ain't true. They, in fact, were on this double secret probation or whatever. And so that's what started this, Judge. And so now it's become a deep dive into years and years of this hospital.
Well, I
and
think
so
what started
if the
is
Joint
when
Commission...
I think what started is when the defense presented evidence before this jury that says that the Joint Commission had blessed Johns Hopkins All Children's Hospital, giving
Whitney needs to call Mr. Anderson
is
right now.
a very false impression.
Well, Judge, so that's...
And not just the Joint Commission, also federal agencies.
So that's the issue.
He's there.
So if, in fact, the Joint Commission in 2018, which would go back over the years that are involved here, passed the hospital, and then it was only after that this issue came up with the heart stuff, then we were, in fact, accredited in 2016, 2017, when this is the thing. So to go back and deep dive into the whole hospital seems a little extreme for the issue that this is addressing.
Well, I just fundamentally...
I can answer a couple of the courts.
Okay.
I feel very strongly at this point that a deep dive is not only necessary, but is required, and I'm directing it.
Okay, so I don't...
It has to happen immediately.
I understand. I'm just not clear what the court is asking for with respect to time frame and also what documents.
Well, again, I'm asking, when did
Can I get...
When did this president become president? I don't know the answer to that. But if we're talking about something systemic that was a culture that was pervasive through the hospital, then I need to know how long senior leadership was involved. Because if we're talking about the creation of culture, it generally starts from the top down. Now, sometimes it's bottom up, but that seems to be something that I need to know.
But isn't the first threshold question, was it systemic? Before we have to dive deep 20 years or however many years this guy was president?
Well, how am I going to make that determination?
I think the reports would make that determination, and the deposition on Friday.
And I don't have any more hearing time between now and when we walk in on Monday.
Well, I feel like I can't address the court's concern. I do not have the knowledge as to when this guy became president.
Okay, I can. Mr. Whitney, when did this person? Well, who are we talking about first? Who's the president?
Jonathan Ellen. He was brought down from Baltimore after the acquisition.
When was the acquisition?
The acquisition, 2011. I believe, was 2011. I might be wrong on the date.
It's 2011.
Okay. So when Johns Hopkins All Children's Hospital took over All Children's Hospital, the fellow who lost his job became the chief of All Children's Hospital. Is that what you're telling me, Mr. Whitney?
Yes, Your Honor, except I can't represent that he immediately became the president at Johns Hopkins All Children's Hospital upon the acquisition. I can only represent that between the time the hospital was acquired by Johns Hopkins and the time that Maya Kowalski was a patient there, he had become the president and was the president during the relevant admission.
So I can find that out, Judge.
So why don't we do this? President. Whenever that person became president,
2012.
That's the date range.
And you're looking for the Joint Commission report from that date forward.
And the federal agencies, however they interact with each other.
Whoa.
Okay, I'm not trying to be difficult. That's kind of vague, but I'll report it.
I am doing the best I can. Again, I am going to take a very broad view of discovery. So if there's any hint that it might be relevant to this concept, it needs to be turned over. I am going to look on very disfavorably if I come in on Monday morning and I get a list. Well, I didn't get this report from 2017 because I didn't use the proper language in my discussions. Because
I'm hearing the court, Judge, and I'll do my best to articulate this.
You've got to do your very best.
Described.
Your Honor, if I can inquire, only because I kind of missed how this became a thing in this trial. Very quickly, does this relate to the punitive damages for false imprisonment and battery? Does it relate to the negligent training? I'm not quite sure I understand why we're doing this. That's all. I just don't know what issue it triggered all of this. I just trying to figure out.
Well, what triggered all this is the defense presenting an impression in front of the jury that the Joint Commission has blessed All Children's or Johns Hopkins All Children's Hospital and basically said everything was fine. And that possibly is either a correct statement or a materially false statement.
Okay.
Very materially false statement.
That's a key word, materially false.
I understand the court's directives.
Anything else on this issue?
The lawyers know what that means.
Can I?
And the
as long as we
implications.
have some date certain, time certain today by which we would know something.
Well, I don't know what that means. I think
we've got a deposition tomorrow, right?
I would say that the court's comments have expanded the materials that we thought we were producing. So I need to get that information.
I'm not sure I expanded it. I just was.
Well, we went back in time.
Enforcing it.
So.
We have to have a little bit of time to go through these documents before we depose them.
I've said what I'm going to say on it. It's an expansive, given the position we find ourselves in and how this came up. So let's talk about how Monday morning it's going to shake out.
Yes, sir.
Because I also, am I getting a motion to disqualify one juror or two jurors or three jurors? One juror. Okay. And that's going to be filed today.
Yes.
I want to first, when we walk in, I want to first address the imminent jeopardy finding issue.
Okay.
That's going to be the first thing we're going to do. And any sort of follow-up. My hope is that if there's any further testimony that has to be done, the plaintiffs are ready to bring it. So we can end this case, a few minutes after we bring the jury in. The second issue I think we need to address will be the juror issue.
Yes.
And whether we do that before or after the jury, I don't know. It just depends on how long it takes us to deal with the first issue.
Understood.
And then the next issue after that would be if there was any sort of remaining jury instruction issue, we'd probably have to address that issue as well. My hope is we won't have anything at that point. Do either side see anything that we also have to address?
So long as the admission of additional exhibits falls within that first category of discussing immediate jeopardy, no.
When you talk about admission of additional exhibits, I mean, is it going to be tied to either the initial jeopardy issue or that one policy that we talked about yesterday? That's what you're talking about?
That's what I'm talking about, Your Honor.
Yeah, because I'm not seeing this as we're just reopening up discovery or evidence on other issues, because that's not what we're doing.
Understood.
Okay, anything else on that?
I think so.
No, Your Honor.
Okay. Thank you all very much. I will see everybody on Monday, but I'm sure we'll be in communication via email over the next few days.
Thank you, Judge.
We are in recess.
Thank you, Judge.
We have all of the.
There we go. All right. We did call it. I said the defense was going to turn over some documents that were ancillary to the actual report, that they were going to turn over the things that made it look most favorable to the whatever approach they were taking to defend themselves in that position. That appears to be what happened. The deadline was this morning to turn over that report. It was not turned over. We can tell that from Mr. Anderson's report and from Mr. Whitney's report. They turned over a letter themselves that basically proves there's more, and now the judge has made it very clear. It's very clear. If there is a scintilla of scent, was that what it was? If there was a hint of a smell on any document, from the time period when the president took over till now, and he was fired in 20. Let's see, according to STPE Catalyst STPETE Catalyst.com. Johns Hopkins All Children's CEO steps down. That was reported on December 11th, 2018. He says, from when he took over till now, all the reports, including the federal agency reports, he wants everything, and he will take a very unfavorable viewpoint on them not turning something over. They have to turn it over now. He made it very, very clear. And Hunter is probably kicking himself, because if he were here, he would have fought that very, very hard, very, very hard. Everyone, Cruel's, she's not the person to fight that. This is not her dog, right? This is not her monkeys, not my circus. Yes, she's related to this, but she's had nothing to do with that, and she doesn't have the knowledge about it. Okay, and so she doesn't know what to argue and what not to, and she's trying her best to be like, look, I'm just the messenger here. I can't, I'm the wrong person to argue this. But the judge gave her the message and said, you be the messenger and carry this message to your team and carry it to the hospital. This is what I want, and this is what I'm directing. And so it's going to happen. This is such a seminal case in my field. I can't even express to you how much Just a red girl. Thank you. Thank you very much. Casey says, so what trial are we covering next? We're not quite done yet. We're not done yet. We've got a little bit here to go. But if you have a suggestion, do let me know. Some of them we have to file some paperwork to get access to. So let me know on that one. I do want to look at, I want to follow this judge. I want to see him in another setting. I guess the next big trial he's got is the Gabby and Laundry Petito case. And that's also a civil suit, but I'd be interested in that one as well. The rest of the defense team is freaking out. You saw Ms. Carell's look down at her phone and just glance down at that while she was writing. She was getting a call from her defense team. Jules, how are you doing?
I'm doing good. How are you?
I'm doing just great. This morning was spicy.
It was very spicy, and I have tried. And I'm sure you realize this, Scott. I have tried to be as accurate as I possibly can, and I have held back on things that, well, you don't know this, but you're about to. I have held back on things that I know, because at the time, I did not think it was proper for me to speak on. So I would not answer some of your questions or some of the chat's questions, and not even on my own TikTok. I didn't even go down that road until I knew and I was confident that I could do so without causing any issues.
Right.
So on that note, let's start. You asked me last week, what did I know what those piles of papers that each of the lawyers received? And I did not answer you. But I can now. The only reason why I can do it now is because of what happened yesterday in court. So now it's going to be common knowledge.
Right.
Okay. So let's back up a bit, because you were able to hear some of the conversations at the bench that we couldn't hear in the gallery. Okay. When Shapiro kept saying, I think you had said he used the word hostile or biased or something to that effect, according in reference to the jurors or juror. That pile of papers were jury questionnaires and jury questions.
Ooh.
That's what that was.
So they're going through all this to see if there's something they missed?
Yes. Now, I can also confirm to you, because I don't know if it was you that asked or if it was someone in your chat, were all the preemptory strikes used during jury selection? Okay, I was not there for jury selection, but I can confirm to you that the defense did not use all of their preemptory strikes.
Which basically means they're happy with everyone who was on the jury at the time the jury was seated.
Correct. Absolutely. That's what that means. So why they are crying foul right now, I don't know.
It makes their argument much weaker. If they had used all their strikes and had objected to the jury and said they were biased, they would be in a stronger position right now to say we need to remove this juror. But yeah, that's interesting. Okay, go on. Sorry for the interruption.
Yeah. So no, I'm because you're providing clarification as well. And where is it? Oh, I don't want to change subjects, but I do, because okay, here, I got it right here. I just have to put my other glasses on so I could read it. Now, the only thing that they can do, and they have to prove this, and I can't see how any of this will apply as far as removing a juror during the trial. And here it states, this is the one part that they may get away with, but they're going to have to prove it. Biased for or against the defendant is one of the reasons that they can use. But they have to prove that there's bias. And
the
I
judge
can't
didn't
see
side
how they're
with
going to do that.
They raised that when questions brought in. They said, this shows the juror's bias, and the judge says, no, it shows they're paying attention, and that's not a bias. And he asked the questions oftentimes that the defense felt was biased. So
Okay. And another reason would be contact with the defendant. Well, in this case, it would be the plaintiffs, or refusal or inability to follow the law. Well, we don't know that because it hasn't gone back to them yet. Also, inattention or sleeping. I can tell you, no, there was no sleeping. I didn't notice any of them dozing off or anything like that. Now, inattention, I can say that, in my opinion, I don't know that juror number 8 for sure, but my opinion, my observation, I felt like she wasn't as attentive as the other 11 were.
I don't know.
And disobeying.
Growing up,
Growing
up, when I was in school, I learned best if I was looking out the window at the same time. I can hear what the teacher is telling me, but if I'm staring at the teacher, my mind wants to be anywhere but there. But if I could look out the window and watch the cars and things, and maybe this is where I got my skill of being able to just repeat everything I hear. But I learn best when I look like I'm not paying attention. So it could be that. That would be a difficult thing to prove, to say you weren't paying attention. I mean, is there a quiz they give her? Say, oh, what was the third witness on day 7? How do you prove that?
Yeah. I know. I don't know. And then it's disobeying court instructions. It says jurors can be removed if they don't follow important instructions from the judge, such as not using their cell phones, etc. Now, there was an incident in court one day last week with juror number 3 and his cell phone.
And
it went off twice. Yeah. Mm-hmm. Yes, and it happened twice. But juror number 3, I don't think it would be him either. Absence from the courtroom. Well, they haven't been absent from the courtroom. Refusal to deliberate. Well, they haven't gotten to that point yet. And so there's a lot of things, but the defense is gonna have to like really. They're gonna have to bring proof. Now, I checked the court, clerk of court about 15 minutes ago. That motion is still not there. Now, they have until 4 o'clock to get it filed. Okay. I suspect they're going to wait to the last minute. I was hoping not, but I suspect they are. If they get it filed if they get it filed by noon, after 2 o'clock today, it'll show. But if they wait until the last minute, then I can't get access to it until tomorrow.
Do you have to? Do you have to pay for it?
No.
Okay. All right. I was gonna say I'd like to cover that if you have to pay for anything, but yeah.
No, it's free.
Let me know. Do you have to be there in person though? Is it or do they have a good?
No.
Online? Okay.
No, I can pull it up and I can pull it up. Yeah. No, like here they noticed they filed on the 1st. Well, I'll tell you exactly. They filed stuff yesterday too, but it didn't have anything to do with that. It had to do with my laptop is so slow. Come on. I hate technology. Let's see. Yesterday they filed, that was the court appearances. Okay, on the 30th and the 31st, they filed, and this is both sides did this, both the plaintiffs and the defense filed objections. This one is for the plaintiff's counter designation and objections. This had to do with that, and I know I'm going to screw up the name. I'm terrible with pronouncing names, but that Paola Patron woman. So they filed an objection in regards to her, and they state the objections for that it calls for a legal conclusion, foundation, predicate calls for a legal. This is all, I guess, to preserve the record for appeals. So they have to file all kinds of stuff. So yeah, they've been so.
Did I lose you?
That's not an issue. So that's where this is coming from. I just can't see. Some people are speculating that it might be whoever the juror is that has the legal background. Other ones are speculating it might be the one with the medical background because of the questions. But you knew this.
Yeah.
If it is the law enforcement person, you knew it. If it is the nurse, you knew it. And I don't think there's just one person on there with a medical background. I just don't. I don't know.
Are the jurors writing their numbers on their questions? Do you know?
I don't know.
Because they have to be able to track it back to the right juror. And I'm sure they can probably figure it out. But just red 1, red 2, red 3 is more of a court process documentation. I'm thinking they must have a juror number or something on the corner. But
maybe, but I don't know.
Here's what we want to do. We want to talk a little bit about the Joint Commission stuff. This is what we all came for today, right? The jury instructions are very important. They're crucial. There's a lot there, and it got very dense in the weeds. Sometimes it sounded like the judge was throwing things out. Really, he's just fine tuning. There weren't major changes to any of the allegations or anything. There were some things where they said, as to this charge and the punitive damages that relate to Maya's need to be, hospitalized in the future because of what happened in the EEG room, the judge says, no, not that. So he didn't throw out everything that happened in the EEG room. Know that everything was just fine-tuned so that the instructions are more clear, and they aren't like asking the jury to find damages for things that really didn't happen or wouldn't be relevant. There are still plenty of places for the jury to find all the damages that they want. Really, those are all still there. The big thing is this document. This document that was supposed to be delivered by this morning, and according to Mr. Anderson, saying we still don't have it. Mr. Whitney, we still don't have it. The judge has now directed the defense through Ms. Corrells to get all these documents, everything. Sorry, I've got a lot of feedback from you, Jules. Is that better?
There is. Oh, maybe because I stepped outside. I went to go check my mail. Sorry. Okay. I listen. From what I heard him say, he's not playing now. I would suspect that he knows, even though he cannot do research himself. I would suspect that after what went down yesterday, he knows. He knows that there's way more to this, that there is no way that Anderson and Whitney would go out on a limb the way they did yesterday without having the facts to back it up.
Right. This is they're not chasing a rabbit. They know exactly what's the end of this road. And they're pursuing that because it's massive. It's massive. It's huge, and it looks really bad. Yes, before defense presented their witness, I think it was Mr. Anderson, right? Attorney witness Anderson, that said the hospital was great, that everything was wonderful,
right?
It smelled like roses. Before that happened, this would have been more prejudicial than probative, and it would not have come in.
Absolutely. It wouldn't have.
But
There's no way.
because they opened that door, because they tried to get this little bit in to make them look a little bit better, and this happened with Mr. Hunter out of the room. Okay, Mr. Hunter was in the middle of all this when this all went down. He was the lawyer for the hospital when this all went down with the IJ. He has his own personal files. He's got pretty much everything that the judge is asking for. Okay, so he knows. I don't know why he wasn't there. He has been sick, but he was not there that day. He did not hear that testimony, and that
I do believe that. I think that was the day he went to the doctor for his back.
Yeah, I think that right there is maybe the only thing that's saving him from maybe some serious personal career repercussions. Because when the judge used those words, material. What he said? Material. What's the second word? He used it today. Inaccuracy. Judge will tell me it was a material. Basically, it's like saying lie. It's as close to lie as you can get. Okay. It's a material inaccuracy or something like that. That is something that an officer of the court, who all the attorneys are, all the lawyers are, material representation, material false statement, material misrepresentation. That is something that the attorneys, if they have personal knowledge, if they know that what is being testified to on the stand is wrong, they are required by their oath to correct it. And it was not corrected. So they have to materially false. That was it. I think it was materially false. Thank you for that. Z, a bunch of you got that. I just barely saw. It was scrolling across the screen. So when the judge was hinting at that, if you go back and watch the part where he says this materially false, that's what he's talking about. It's not just the case that's implicated. He's like, this is huge. This is huge for the attorneys involved, and he wants to know exactly, where this goes, and it could have implications beyond the borders of this case.
It can, but a lot of people are blaming the witness, and you can't blame the witness if he was only given a summary to read. So he was testifying to what they gave him to read. So
that
the fault lies with the defense.
Yes, because
the
inaccurate information starts from the defense and goes to the witness, who just parroted what they told him. They gave him a summary and said, here's what the documents are, just say these things. And he read it and he said those things. And then on direct cross, he's like, when they questioned him, said, you never read these reports, right? You've never seen them. He's like, no, I just said what they told me to say, and charge a lot of money to do it. So that really did throw the defense right under the bus on this one. So it's not looking good. I don't.
And they only have themselves. No. And what is annoying, and I would love your take on this, is that yesterday when Hunter turns around and says, "Listen, I'm not general counsel. I'm just whatever," he said, but meaning that he wasn't involved in every little thing that went on. That's not true. He was very much involved. Very much involved.
Yeah, there was a level. General counsel would be the on staff, and he was brought in from the outside. So he was outside counsel as compared to general counsel, where general counsel would be a little bit more involved than he would. But he admitted he's got all these files in his personal files, locked away. He thought he buried this Dracula years ago. He's got his fingers all over this.
That speaks volumes. Yeah, that speaks volumes, doesn't it? And I think that he's regretting the fact that he even made that statement in open court.
The other statement I heard today that I think might be regrettable, and it's not related to this issue, but it was Mr. Alderman when he was doing his story. When he was telling the story about his uncle who was in World War II. Okay, it's terrible. My heart breaks for him, the pain, the heartache the family's gone through. That aside, he then related that to Maya and her family's situation, and with Beata, and he talked about, and he drew a similarity to the judge in Maya's case being not responsible for Beata's death. Okay, and he used other words, but this is how I understood it. And he said, and I would put on the record to the court today that judge has no responsibility for what's going on here today in this court, meaning that judge shares 0% of the blame. Who else is there to blame? I don't know why he would say that. Why?
I don't know why
they
he
have
said
this
it.
huge umbrella protecting everything that's over there, and they are protected. And they've been saying all along, it was the court. It was the court saying you couldn't hug the daughter. That's what pushed her over the edge. And here he is saying, on the record, you can put on the record, that judge had 0% of the blame. The only other person on there is them.
Exactly.
That's the
and
only other person.
Here's the key, okay? They went to court on January 6th. Judge Hayward said, nope, you can't hug your kid. Basically, goodbye. I'm going to see you in 44 days. I believe the next dependency court hearing was February 22nd, I believe it was. I do know for a fact it was 44 days, so however that works out. 44 days, okay? If the judge didn't play a part in all of this, she did this the very next day, okay? When the next court hearing was 44 days out, she did it the next day, and 6 days after she did it, miraculously, Maya was released.
Yeah.
How does that make sense?
I don't know where the jury will sit. I don't think the jury's going to hear that comment from Mr. Altenberg. They're not going to hear that judge was never responsible for anything that happened. It seems like they've been trying to say all during the case that it was that dependency hearing that's at fault. That was the last straw for Beata. But
right,
crazy.
And the other thing was, and they want to say he also kept regurgitating that it wasn't anything that the hospital did that caused Beata to do this. And, he was going the impulsive, I have to talk to Scott Richards. He's the psychiatrist. All of that stuff. I got
irresistible
in trouble
impulse.
yesterday, by the way.
You got in trouble?
That's it. Thank you.
Yeah.
I did. I admit it. I got in trouble.
Okay.
Yeah, we're not going to talk about that. What do you call it? But in my opinion, it is because had the hospital not initiated that phone call in the first place without thoroughly checking with Maya's primary care physician and all the other physicians that were like Dr. Hanna and Dr. Kirkpatrick, which, by the way, I met him and he's a very lovely man. In my opinion, and I could be wrong, but if they didn't initiate that call before following what they really should have followed up on the information that Beata was providing to them, we wouldn't be where we are today. And I also think that the nurses and even the doctors may have been intimidated by Beata because of her knowledge. I mean, she was very knowledgeable as a nurse. I mean, even borderline
and demanding
physician.
She was knowledgeable and demanding. She was not afraid to put her opinion out there as just what she thought should happen.
Right. And I can also tell you, for a fact, that what Jack testified to about the baby books, I knew about this for weeks, okay? It's true. What he said, that is what Beata did. And with those emails that she wrote to herself, but in regards to Maya being, like speaking as Maya, I do believe that this was her way of documenting Maya's story for Maya at a later date in time, as the child would grow. And if she had questions, here, this is what happened.
Yeah, it's amazing. We are so close to the end, Jules. We're so close.
I don't know. Are we?
Monday.
Are we?
Well, We're close to the first.
I don't know.
This is there are going to be several chapters in this book before it's
Yes.
done, and there might be several volumes before the series is complete.
Yes, and the deposition is being done tomorrow.
Mm-hmm. That's going to be a hospital administrator who can testify to all the documents that the judge has made very clear should be turned over. And when he says turns over, it means given to the plaintiff. Okay, not just like looked at and said, "Oh no, we don't think that's important." He says they get them all, very broadly. I've never heard a judge be so clear about how broad. He's like he was. It is the widest, sweeping request I've ever heard of as far as documents go. This is massive.
Me too. And he's mad. And what they're trying to dance around, they keep bringing up, well, this is the January 11th, 2019 report. No. It was the follow-up. That report was the follow-up from the actual report in September of 2018. And the report in 2018 covers the prior 3 years. And they do this every 3 years. They review all hospitals. They do it every 3 years, and they cover it for that 3-year period.
Which means it covers the period of time that Maya was there at the hospital. I mean, you look at the president of the hospital. The judge was asking a lot of questions about did someone lose their job over this? He knew somebody lost their job over it. He lost his job at the end of 2018. Okay, so you do the math backwards, and it's clearly going to be at least in time scope relative to this case.
Yeah.
Now, as there may be something, and I think on Monday we're going to see this is about the only thing the defense is able to argue, and they're going to fight this hard. And there may be that there was an initial report about the heart thing, and that triggered a further investigation. I think there's no way that they can just pin this all on the cardiac unit. There's no way.
They can't.
It's so broad. It's so broad that it's.
To my understanding, I mean, this report even covers the janitorial service.
Yeah.
I mean, so it wasn't just the child's cardiac unit. It was the hospital as a whole. I mean, janitorial service, they've got in the original report, they've got that listed in there. It's insane. I don't think they're going to make very much, at least I hope they don't, but I don't think they're going to make very much headway come Monday. And if Whitney is the one doing the deposition, it's going to be brutal for whoever it is. And it wasn't just that one guy that lost his job. There were over a dozen higher ups.
I heard there were at least 3 upper level managements. There might have been more.
There was more.
Here's what happens if Whitney does this depot. This is not like a depot where you're on a fact finding mission. He knows what the facts are, and he knows how to word the questions. And you're going to have a witness there sworn to tell the truth. It is going to be through gritted teeth answering every question, and it's not going to look good. We're not going to see that. Obviously, that depot is not going to come into the court. That's just to determine, if they have all the documents they need, and even what's going to be presented to the jury might be a much smaller window of information than what we're hearing about right now. They're not going to hear about the president being fired and things like that. I don't think that'll come in at all.
No, because I don't think it's relevant, actually.
Right.
But also remember, Nick is a former JAG officer. That's big.
Yep.
That's big.
Yeah, he's.
If you have a JAG career, if you have a JAG career behind you, that's pretty impressive.
Yeah. Monday is going to be fireworks, and it's going to start from the get-go, because this is the first thing judge is going to do is address this joint commission stuff. He doesn't want this to drag out. He wants everything presented, a decision made, and move forward, because they're on a tight time schedule, and they've already pushed it. So it's Monday is going to be the day to watch. Nothing happens tomorrow, right? Other than the depot. But that's not going to happen in court. That's not going to be live streamed.
No.
That'll be at the hospital or a hotel or somewhere else, a lawyer's office.
And what I what I can, no, I better not. I was going to verify something, but I'm going to wait on it.
Yeah, hold on. Use your,
I'm going to hold
your
off.
discretion.
Yes, but I hope you understand why I didn't answer your question last week when you asked me about the reams of paper, because, you know, I knew what it was, but I wanted to wait, and now you know. This is what the defense wanted, so it went to everybody.
So the big issues that are still staying out there right now is this IG stuff, the immediate jeopardy that the finding that came from the Joint Commission. That report, we should, under the judge's ruling, it should come in now. I would be very surprised if it doesn't. I don't think defense would risk fighting this now. The genie's out of the bottle for all intents and purposes. There's not a lot of grounds they can save by fighting this document. And so I think that's coming in. And then I think that Mr. Whitney is going to be able to present some evidence to contradict the evidence that the defense presented. And that's going to be fairly quick as far as the jury is concerned. It'll be huge in court, and it might have other ramifications. That's happening. Defense is also filing a motion that you're watching for on the docket for the dismissal of a juror. They think a juror is biased. They think a juror may have, broken, they obviously, if they're filing a motion, they think that they violated one of the rules to serve on a jury, whether it's, coming in with a preconceived notion or refusing to follow the law, you name it. They're going to have it. They'll have it in writing. It will be in the motion. They're going to have their reasons as to why. Judge is going to look at that, and most likely that's going to be dismissed. You're going to, if there's something the judge doesn't know, we may see this Monday morning where the judge brings in one juror and talks to them and asks them questions. If there is even the tiniest hint of there could be a problem somewhere, if one of the answers smells a little funny, the juror will be dismissed. Okay, there's no way the judge would keep it, and we saw that in Alex Murdaugh's trial as well, where the lady, I think, didn't really do anything wrong, but he's like, just out of caution.
It was her ex-husband, though, wasn't it? I thought it was her ex-husband that made Facebook posts and then pulled it and made Facebook posts stating that she was talking about the case. Yeah. Wasn't that what it was? The egg
something
lady?
like that. But she's all her answers, I think she said she hadn't, and she had followed the rules. And the judge is like, "Hey, thanks for your service. I might remember this wrong." But if there is any problem at all, if the judge uncovers anything on a juror that was inappropriate, the juror will be dismissed. That's why they have alternates. Okay, if a juror gets sick, a problem arises with a juror, that's why they have alternates. So that is a possibility if they have something. So that could be a huge situation as well. After that, Monday as well, we have closing arguments for both sides. This is where they have fought over this since the get-go. And they're like, I don't want to hear the other side saying this in closing arguments. I don't want to hear you guys arguing this and saying we didn't do this. They have fought about this back and forth. The truth of the matter is, when it comes to closing arguments, they are not testimony. Okay, the jurors are not going to be like taking notes like, oh yeah, that's right. No, the notepads go down. They just listen. They listen, and they are not going to, and there will be objections. It will be spicy. It will be back and forth, but it will.
There better not. But objections during closing arguments are very frowned upon.
They're bad form.
They're bad form.
Upon. They'll happen.
Yes.
Mark my word, they're going to happen. Okay, it's gonna happen. There's just so much they've fought over, and they're not on the same page on. That they're going to say, Your Honor, I apologize, and it might be very respectful. I'm sorry. For the record, we have to object to this. And anyway, but the closing argument is where each side bundles everything we've heard over the last month and a half, and into one big package, and delivers it to us, hopefully in a very understandable, easy to follow, chain of thought, and then says, this is what happened. And we want you to agree with us. And the other side comes out and they're like, no, this is what happens. We want you to agree with us. And then after that is done, the jury gets, or it might be before, depending on how it happens, the jury gets read their instructions, the jury instructions. They get read the verdict form and how to fill that out. And then they go into deliberation. And so next week is just going to be huge. Every single moment of next week is just going to be amazing. You don't want to miss that.
Yeah, so and they're starting at 8:15. They're taking. They start at 8:15, so I'm going to make sure I'm there like at 7:30, because I just have a gut feeling that, and I could be wrong, but I have a gut feeling that that courtroom's going to be packed because of these bombshells that went off yesterday.
You'll have to be there early for sure.
Yeah, I'm definitely going to be there like really early. And if I call you crying,
it'll mean you're in the overflow room.
No, if I call you crying, no, I promise you I will not be in the overflow room. I promise you that.
Okay.
That means it's one of my favorite jurors.
Oh, man.
Because I will be like super upset, because I do have some favorites, and I don't know if these jurors are, going to be the ones deliberating, but I've got to suspect that, because the lawyers know.
Yeah.
So I've got to suspect that if they're going this far, it's got to be about a juror that is going to be deliberating.
That's become one of your favorites.
And that's going to be.
Yeah.
Yes, I know. But it's got to be, and it has to be someone that they know is deliberating. Because why would they do it? Why would they call for a juror dismissal if it was for an alternate? That wouldn't make sense.
Yeah.
Right?
I think they still might do it because it might help their case on appeal if they can show a biased jury and one was dismissed. I think that might look better. So I think they would even move to dismiss one if they knew it was an alternate, just in case.
Really?
Because what happens if they don't, and one of the jurors, deliberation day shows up and one juror is like deathly ill. It's like, oh, it came down with the swine flu or whatever thing's going around. Came down with something, can't show up to court, can't deliberate. Judge reaches into the hat and pulls out the other juror. So for that reason, the chance that that other juror might get on the jury if one of the original six is not able to, I think they would make an objection even if they weren't originally selected to deliberate.
Okay, I'll take your word for it.
Don't. I don't recommend doing that. That's just my opinion. But all right, Jules.
Okay.
I have to get with you offline. I'm looking at sending you a little thank you. So I'll reach out to you offline through text if that's all right.
All right, guys. Yeah, no, you've got my number.
Yeah.
Absolutely. Feel free anytime. What do you call it? But yeah, I'm gonna run because this trial, no lie, it has consumed me to no end. So I'm going to take the next 4. Well, maybe not. I don't know what I'm going to do.
You schedule a vacation day for the day after trial? Is that what you did? Schedule a vacation. Book that long cruise.
I wish. I wonder if he canceled. I doubt that he did. I think Monday. I just think that Monday's going to be a very long day. I don't think it's going to break at 5. I think it's going to go past 5, only because there's so much going on Monday.
It's going to be a packed day. It's going to be. We probably were going to work through lunch on that one. I'm not sure. So bring a sack lunch on that one because we'll have to eat at our desks. But
well, yeah, I'm going to have to for sure because the vending machines at the courthouse are awful.
And eating at a vending machine is not a good lunch. I would choose a food truck. I would choose a random food truck over a vending machine. I'd risk it on the food truck.
Dude, I've been doing the vending machine every day for 7 weeks. So yeah, it's poor. It is pretty poor.
You've really,
anyway.
Jules. I can't say this enough. The chat and I and everybody in the whole community appreciate so much what you've provided for us. The insights, the feedback,
not at all.
The updates. These have been wonderful, and I'll get you a thank you for that. I definitely appreciate it. This is not a small thing. Going to court every day, this is a huge endeavor, and you've been doing this day in and day out. It's been amazing.
Yes, but Scott, I was going anyway, and I found out about you because I have followed Rob from Law and Lumber for a long time. I found out about you through people in his chat that follow you. And they're like, you should contact RA. And I'm like, who's RA?
Never heard of her. Yep.
I never heard of them. And so I was there anyway. And then, when so many people were like, please get in touch with RA, and and then they DM'd me, and that's how I found out who you were, and that's when I reached out. I didn't know if you were going to be even receptive or not, but people were asking me to contact you. So
Jules, you have a skill. Your observance, your ability to observe and document and record and recall and then share that information is not common. You are extremely observant. This is unique. It really is. You're really, really good at what you do, and
I try to be careful too. I really try to be careful, and because I don't want misinformation or things to be misconstrued. And unless I know something for a fact, I'm not going to say it. The one upside to this case is I met quite a few people from your chat and from Rob's chat that over the last 2 weeks have been floating in and out of the courtroom. Lovely people. Also, I did not know this family. I knew of them, but I did not know them. And going through this experience, I have come to know them. And I feel like I made friends for life when it comes to this family. And so, yes, I've had many conversations with Jack and the kids, his brother, his sister-in-law. In fact, his sister-in-law was there yesterday. But I will never reveal those conversations unless it's something in general and that I have, permission to. But the one thing that I can say is these are very lovely people. They have a deep conviction in the Lord, despite what some people may think. They are very kind people, and they are hurting, and they want this over with just as badly as everyone else does. And
hey, Jules.
And Maya is around. Go ahead.
Can I interrupt you a little bit? There are a lot of people who want to thank you in a very just a small token, personal way. Do you have on your TikTok or something? Can you share? Do you have like a Venmo? Do you have a PayPal, something like that, where somebody who does want to just say, hey, let me buy your lunch today as a thank you for what you've done? Do you have something like that where we could share that would go directly to you?
I do, but it's not. I don't have it on my. What do you call it? On my TikTok.
Okay.
Where is it? I have, because I'm terrible at this stuff. It is. How do I find out what my? Okay, the Cash App is.
Can you send it to me in a?
J.
Okay, send it to me in a.
Okay, yes.
In a text. I want to make sure I get it right, so I can pull it up. And we'd like to share it. I'd rather not be in the middle. A lot of times people want to send me something to send someone else. It for tax implications and everything else, it makes it really, really difficult. But if we could send something directly to you and tell me what it is really quickly over air, so everyone knows that that's yours when I post it.
Right. It's J, the letter J, the capital J, capital B as in boy, and then E. LLA 1423, and that's both for PayPal and Cash App.
Okay, one more time.
Guys,
J-A.
No, J-B E-L-L-A. Yeah, B as in boy, then E-L-L-A. So it's J Bella 1423.
1423, and that's on Cash App. Okay.
Cash App and PayPal, they're both the same.
Okay.
But listen, everyone, that's very kind of you, and I appreciate you guys, but it really isn't necessary because I was there anyway. I was always there.
Jules, they know it's not necessary. They still want to thank you. What you've done, what you provided, the answers, the feedback, the work you put in, they want to thank you. That's all I can say. So we'll share that out. We'll share a link and maybe might pay for lunch. Might pay for something other than a vending machine. We want you to stay healthy and happy if you're there for us.
But I don't want to leave. And I am staying at the courthouse for deliberations. Yeah. None of us are leaving because he's only, the max he will give is 30 minutes for even if it's a question, the max he's going to give is 30 minutes. So we are all staying put. Yeah. We're not going to leave.
It's going to be quick. It's going to be fireworks. It's going to be great. Jules.
It is. I just don't think the verdict is going to come back as quickly as I would like, but it is what it is. But anyway, I know you got to get back to your chat.
It's all right. Have yourself a fantastic weekend. I know you're going to be on Document Watch. We'll watch for anything that drops on your TikTok this afternoon regarding that as well. If you can text me if you see something, that would be great as well.
I will.
But
I'll send you the document.
Take some well-deserved time off this week and get ready for Monday. Buckle up. It's going to be crazy. Thank you so much,
It's going to be a wild ride.
Appreciate it.
You're welcome, everybody. Have a great weekend.
Yeah, we'll
all right. Bye-bye.
Bye. All right. That is awesome. Let's see. Did you catch Altenburn mock Beata? Oh, man. Mr. Altenburn, I like him. Okay, first of all, this is a judge who has experience. Or he was a judge. He's an attorney now. He was attorney before, so he's attorney, judge, attorney. That's how it goes. He has tons of experience, and it seems that sometimes in his analogies, in his exuberance to share the analogy, he loses track of the people factor that's at play, and so I'm not gonna fault him for doing that. I think it sort of comes with the territory. He has to express a story. He has to express a point and an argument, and in some ways it will sound insensitive. It'll sound insensitive. It'll sound like he's belittling a situation that other people will be like, how can you belittle the loss of Maya's mom? But he's got a job to do, and he's stuck between a rock and a hard place. So I'm not going to fault him there. Let's see. Anything else we need to cover today? First of all, there will be no court tomorrow here in this trial. We're going to do court hopping tomorrow. If you've not been court hopping with us before, it is a lot of fun. There are courts all over the country that are holding trials every day of the week. And some of them are handling small drug offenses. Some of them are handling petty crimes. Some of them are handling shoplifting. Just all sorts of things, all the way up to just other murder trials that happen very quickly, and guilty pleas and not guilty, and all the court work that goes into leading up to a trial. All that is happening all over the country, in courthouses all over the country, and a lot of them are live streaming their courts. Court hopping is when we jump in and we start following, and we might find a court that we really like a certain person on. We watch for a little while, but we'll jump from court to court as we follow some of these quick hits, the quick court cases. As 15 people follow through Zoom. It might be Judge Boyd has people appearing before her, and some fun interactions there. Judge Cedric and his courtroom, who's also just amazing, just an incredible judge. We'll jump around the country. We might also look at some parole hearings if they have any of those scheduled tomorrow out of Louisiana from the Louisiana Parole Board. We'll be sort of all over the place. I'm also looking at covering tomorrow the latest letter from Sarah Boone. If we've covered all the other letters that Sarah Boone wrote. She did write another one. I know Lawyer Who Knows covered that already. We're going to cover that just so we can have everything on our channel as well, for those of you who want to follow through all the Sarah Boone updates. That case is working its way towards a trial, even though it's going to be early next year at the soonest before that happens. So that's what we have on the schedule tomorrow. So if you have nothing else to do, hey, Mrs. Zara, you want my keys? Or your keys, I guess. Are you late? Is he late? I don't know where they are. Is he late? Okay. All right. All right. So Mrs. Ariel's also told me that we have guests that are flying into town that might show up any minute, and she's leaving. So I might have to get off the air so I can at least welcome them in. So we're going to take the rest of the afternoon off. I don't know what y'all are going to do with yourselves, but if I could make a suggestion, I would say to first go to the people you love, your family, hug them, tell them you love them. Send a note, send an email, send a text message. If they're there with you, give them a hug. And if you don't have that opportunity, or if that's not something that you're able to do, find a stranger and smile at them. Life is amazing. I woke up this morning feeling like it's a new day, and I'm blessed to be able to do this every day. I can't say enough about this. This is my dream, to be able to do this, and every day to spend this with you guys is incredible. So thank you very much. I'd encourage you to do that. Do something. Rob would tell you to build something, which I'm not very good at building. I might have to try it, but do something to maybe get up and walk about a bit and talk to a few people. I don't know. Don't make me feel things, says Adam. Why would I do that, Adam? Tomorrow, of course, in addition to everything else we have going on with the fun day, tomorrow night we have the podcast here on this channel. Weather Watch and myself will be here for the Not Relevant podcast, which is a podcast where we take a little lighter look at things that happen during the week around the world and around the country. It's a fun live podcast. Usually lasts about an hour to an hour and a half, where you get to be involved in some funny, goofy stuff that is really just sort of like a step back from some of the detail, the really heavy, I guess, the heavy things we cover during the week as we cover trials. So we'd encourage all of you to click the subscribe button and come and hang out with us tomorrow night. It starts at 8 p.m. on Fridays. It's the Not Relevant podcast. I think we're on episode like 1,000. What is it? I lost the math. I don't know. I think it's episode 30, 50. I forget. I think it's like 37, 38. I forget. I'll have to look. I should probably know that before I start talking about it. Tomorrow we're going to start at I think 8:30. That'll give you a little bit of time to sleep in, and then we'll join, and it gives the court some time to start around the country, and we'll start jumping around and looking at a few of them. So let's see. 36 is next. 36, says Greeners. Thank you for keeping count of the podcast. Episode 36. All right, thank you to our incredible mods. Thanks to all of you. Tonight when you go home, please hug the people you love. Smile at someone. Make their day just a little bit better. And please stay safe till we go live again. Tomorrow morning we go live at 8:30 in the morning. So have yourself a fantastic Thursday. Tomorrow's Friday. No Pants Friday. Should be fun. Be good to each other, guys. We'll see you.